Welcome, STS listeners, 26, and I've been off the air, been away. My daughter got married, had some Christmas parties, a little vacation, and we're back here. Joel asked me if I'd help cover the Kouri Richins trial, some preliminary evidentiary hearings. Looks like an interesting case. Looks like pretty overwhelming evidence against Kouri. And there's the defense lawyers had some issues with some cooperating witnesses, whether or not one of the witnesses changed the testimony, and they attacked the credibility. Anytime you got a cooperating witness, you, of course, can attack the witness. But when you look at the evidence and you look at the motive and you look at who gained benefit from it, Kouri Richins has a long road to try to distance herself from this murder. And I see that the state then added a bunch of new charges: money laundering, tried like a RICO charge, insurance fraud, just jamming her up. And I don't know if they're going to try them both at the same time, but clearly she could spend a lot of time in jail just on those paper cases, as we call them. This is an interesting case. It goes back to the same scenario. Why don't people get divorced? Why do people commit murder? And it usually involves assets, adds kids, and motives. And this case has all of them, right? Utah, I believe, still does have a death penalty. And so this trial should be interesting. She said she's going to trial. She said she's gonna, it's war. I guess if you're fighting for your life, it is war. But it's so good to be back. I missed all you guys. I missed all your great comments, some of your silly comments, and everybody's been so nice to me and my family. I thank you all again for watching STS. I think it gives one of the best substantive views of cases. Some of the guests are really good to have experience. I've always told Joel that I'm going to tell you what I believe. I'm not going to sugarcoat it, and I'm not going to shy away from if I think what's happening is happening. And I will say most of the guests have been pretty good about accepting that. So we'll do this like always. I'll tell you what I think's happening, what the evidence is, how they're proceeding, what the rules are, what the evidentiary rules are. And if you got questions, I'll be glad to try to answer them. This is kind of a new case to me. I've done a little research on it, and it's not highly complicated, to tell you the truth. They have a lot of forensic evidence and a lot of science involved. So it's going to be good. Happy New Year. Here is Charlie to you. Hope everybody has a 2026. This case has been a roller coaster. Well, let's see if we can't straighten out those bumps and bruises for you, court lurker. I think it's maybe a roller coaster, but it shouldn't be. Anytime you have a murder case, it's a sad case. Again, you have 3 young children they're not an orphan. They may be orphaned soon. If she goes to prison, they'll have to go with another relative, hopefully. But it goes back. Why do people commit murder? Why do they think they can get away with murder? Everything on behalf of this guy, her husband, he was a pretty decent guy. Outdoorsman, good father. And Kouri apparently, I'm guessing they said, had a boyfriend, but had kids. He had the money. She tried to start a business. Thanks, Jennifer. ND98. It's good to be back. I've kind of missed it. I actually had missed it, but we've been getting my daughter married and all that wonderful celebration. And I will say Joel and Ileana came to the wedding, and it was wonderful having them. A lot of my family and friends and people in Tallahassee loved being with them, asked some questions. They felt right at home, which is what Tallahassee is. It's like home. Unlike what the Adelsons feel, Tallahassee's a nice place. So I think Joel and Ileana had a great time. It was great having them at the wedding. And so I'm here to see if I can help educate. I don't want to say educate because everybody's educated, but at least give you some insight from a trial lawyer perspective. I'm going on my 40th year of practicing law, and I had a big birthday in December 28th. I'm now fully a senior citizen, and all is good. So I'm anxious to see how this trial goes, anxious to see how this judge controls his courtroom. And I'm anxious to see the prosecutors because they got a pretty good case. Now, I understand that the Kouri had a private lawyer. Now she's got a public defender. So good to see you postpartum. Texts and letters this woman wrote are absolutely crazy. She belongs where she is. Well, think about it. If you are charged with murder of your spouse and you have 3 kids together, there's something off, right? Something off. And people, they don't just charge you with murder if they don't think they have enough evidence to prove it. And a lot of circumstantial evidence, when I say circumstantial evidence, it's contrary to eyewitness or direct evidence. But circumstantial evidence is, her contacting people, looking things up, that puts her in a motive, borrowing money, doing it without permission, all that shows motive. Direct evidence, there probably isn't going to be any direct evidence because she's the one allegedly, and I say allegedly, I wasn't there and I'm not a witness. She's the one that provided the sandwich that got him sick, and she provided the Moscow Mule that eventually killed him. And I think that's what the evidence is going to be. She was very persistent, wasn't she? The first time didn't work, since she went to this confidential source and then went to another one to get more lethal dose, which turned out to be lethal. And then she had some text messages that clearly showed that she was looking up fentanyl, how can the FBI retrieve deleted messages. Those are all what we would say as consciousness of guilt. The defense will probably say, well, she was just trying to figure out how they're going to charge her. So I don't know. I don't think you're going to buy that story. Common sense usually dictates. You see a motive, you see what happened. Who else is going to do this? A guy that never uses drugs, doesn't do drugs, a good father. He's not going to be taking fentanyl all of a sudden to the degree that he dies. He knew something was up, so he changed his will without her knowing. He got a trust. He put his sister in a trust, put his kids in a trust, and lo and behold, after he dies, Kouri's in there fighting to get into the safe, and the sister's like, wait a minute, it's in a trust. You don't get any of it. So all that evidence points to one person, and that's Kouri Richins. And I think a jury, if they pay attention and they listen to the evidence, it's going to be hard-pressed for them to get a not guilty verdict. But she's entitled. She's deemed innocent until they prove the case. And I don't know if they made plea offers in the case, but she's going for broke. And she has her family members standing up for her. I saw her lawyers did an odd thing. They actually went out and they did an interview with a TV station, which you don't normally do when you have pending case. You don't normally, but they said they wanted to correct the record. And I'm not sure if they corrected the record. So we should be starting. I know it's a delay. So we'll see. But if you have any questions about anything, over the holidays, I did run into a fan of STS named Gail in St. Petersburg. And she came up to my wife and asked her, and we talked, and it was nice. She was very polite. She loves SDS. I asked her if she watches, and I tried to get her name, but I couldn't remember the name, but she said her picture is a cat. So Gail, if you're there, Happy New Year. It was a pleasure meeting you. Thanks for watching the show. Kouri had it all, but none of it was important. She deserves to be in prison for what she does. My thoughts. Rosie, you're right. When people don't realize what they have, they take it for granted until it's gone. The grass is not always greener. People always think it's greener. And the way she did it was just so poorly done. And it's just hard to understand why he stayed. I guess he stayed for the kids. And I think they were doing some counseling while she was getting loans, taking a home equity loan out in his name for her company. Um, Finances sometimes does lead people to commit crimes that they wouldn't normally commit. You had financial problem, and I guess adultery. I guess she was involved with someone else. That makes people clouds their judgment, and a lot of times you see that in these cases where spouses end up, or one spouse ends up dead, and you find out that the other spouse has not been completely committed to the other spouse. So I'm looking at some of these posts so I can till the show starts. Yeah, the way they charge this, Brittany, is they charged her with a bunch of new offenses so that if for some reason she gets acquitted or gets a hung jury, they still keep her in jail and on all the paper cases. My understanding, Kibby, is that her business was not successful and that she was trying to buy this property for like $4 or $5 million and sell it for $12 million. And there was a big dispute about it between her and her husband. And I think right after he died, she went and bought it, or prosecutor can prove the source. You know, Christina, I'm not sure they have to prove the source of fentanyl. I think they just got to prove that he died from fentanyl poisoning, that it was given to him by his spouse, that he doesn't use drugs, and then the confidential or whatever the defendant that's cooperating says that he gave her drugs, the wife. That's a circumstantial link. These drugs that he says he gave, either blues or oxy or whatever he gave her, they're often laced with fentanyl. They don't really know what they're getting when they buy it. So I think that's going to be a real tight circumstantial evidence that the fentanyl came from her, came from this person, regardless of what that guy's criminal history said, regardless what he says, what drug he gave. He doesn't know what drug he bought. He didn't make it. He buys it on the street. He's just a dealer. Is she the one that opened up a real estate when it was failing? That's correct, JFK. This is the woman who tried to run a real estate business, got over her head or got over committed, and couldn't pay Peter to pay Paul. The interest payments were killing her. She took a HELOC loan out without her husband's permission, arguably, and she was upside down. She needed money. She was leaking money and needed to resolve it. And I guess she thought this is the best way to resolve it because everything was not going to go to her. She didn't know it wasn't going to her. He did a trust. He changed his will after the first, I believe, after the sandwich incident where he told a friend, I think my wife's trying to kill me. Anytime your wife's trying to kill you, you believe that, it's time to get out. Real, that should have been a warning shot. But maybe he stayed for the kids. Maybe that's why he's been described as a good person. Bought buying the pills, Michael Jackson drug. I think there are texts, court lurker, between them about buying pills. The question, what pills? And those are devastating text messages. Unless they're going to blame the housekeeper for killing him. What benefit would the housekeeper get? That would be hard to prove. But the defense is going to try anything they can to point the blame away or attack the credibility of the witnesses. It's not the message, it's the messenger. They can attack the messenger, the cooperating witness who's on probation or whatever, but they can't change what was said or what was done, where that person said they gave drugs to Lori or Kouri on 2 different occasions. That evidence is going to come in, very damaging evidence to her. He was found with 5 times, even more than his stomach. And yet there were no traces of any pills, drugs near his body. Well, that's a good question. The examiner saw so much in his system that a normal user is way more than a normal user, and he wasn't a normal user. And there's no traces of any pills or drugs near his body, meaning he didn't get a whole bunch of pills of fentanyl, take some, and then die, and there's a bag or a box or a pill bottle. And there's no other reason why. The timing is very important too. The wills, the financial struggles, everything is going to lead to one conclusion, and that's the conclusion that Kouri Richins decided she was going to kill her husband. I guess we're delayed on the show. We're hearing the hearing is delayed until 12:08. Oh. Well, we can sit and talk, and you can send me questions about the, you send me questions, and I'll try to answer them for you. I think Kouri is going to testify. Well, let me tell you why I disagree, Brittany. Or at least in Florida with Donna Adelson. We saw that she did not testify. And the best defense they have in this case is there's insufficient evidence to prove she committed the crime, that they don't have direct evidence. But if she testifies, then she loses on appeal the argument insufficient evidence, right? Because a jury can convict you on credibility alone. So a lot of times a defendant will not testify because they don't want to lose that issue on appeal, that there's not enough evidence. And they're going to say there's not enough evidence. That's what they've been saying the whole time. And that's why when I saw they called character witnesses in Donna Adelson's case, I knew the defense was not calling Donna. They were trying to fill and undermine all the state's case with character witnesses or witnesses because Donna wasn't getting on the stand. But you see in that case, there was a fight between Donna and the lawyers. Donna wanted to testify. The lawyers didn't want her to. She couldn't make a decision because she knew she'd be giving up an appellate right. And so she ultimately said, I'm not going to. But I think that's the same thing in this case. Kouri thinks there's not enough evidence to convict her. But if she gets on the stand and testifies and does poorly, then she loses. The jury may not like her and convict her, and then she get caught up in so many lies. She has to answer questions. But the important thing is she loses that issue on appeal of insufficient evidence. And that's a big one. And her lawyers or her appellate lawyer will tell her, if you're not going to change the ballgame with your testimony, you don't want to get up there, make them prove the case. We don't think they can prove it. That's what her lawyers are probably telling her. And Katie McBanawa made that problem. She testified and didn't come across, and she got convicted. So she didn't have any issue of insufficient evidence in her trial. So I'm not sure Kouri will testify, but sometimes, yeah, Brittany, I agree with you. Donna Adelson's lawyers set an opening that Donna was going to testify, right? They inferred that she's going to tell you. They never did. It is the defendant's this ultimate decision. And the courts now go great lengths to make sure that they put on the record that it's your right, no matter what your lawyers tell you, it's your right to testify or not. And so now courts will always do an inquiry outside the presence of the jury. They'll make sure they'll give you additional time to make sure it's your decision. And that's you see in almost all cases now. It didn't used to be that way. It used to be that, many years ago, 30, 35 years ago, the defense would say rest. But it got overturned. So many defendants got in prison and said, I wanted to testify, that they changed that, and the judges now make sure that it's the defendant's right. And you saw Judge Everett in Donna's case go overboard, gave her additional time, and then finally said, okay, we're done playing this game. You either are or you're not. So a lot of defendants get tripped up on cross-examination. They do, because they say so many lies, they can't keep up with the lies. And it's hard to find a witness they can do pretty good on direct because you kind of go over the questions, they know what's coming. It's cross-examination that really kills them. And it's not so much the answers, it's their demeanor. We tell witnesses all the time, don't get red, don't get upset, don't let that juror see that side of you, because the prosecutor's goal is not only to get the answers they want, put you in a box, but they want to see you get frustrated. They want to see you get mad. They want to see that you have another side to you that the jury sees, which is their case. And that happens quite often. Recently, my partner had a trial where he said, whatever you do, don't get upset, don't get mad, don't. And I went and watched the cross-examination, and he was pointing his finger, he was yelling at the prosecutor. It was just everything that could go bad went bad, and he was convicted. So yeah, I agree with you, Kathy Wallace. If she committed this offense, planned it the way she did, then her children are at risk, because normal people don't kill their spouses. Normal people don't kill people. They don't try it multiple times. They don't kill people for benefit to go for their financial problem and risk their kids' lives and future by taking away the breadwinner, the father, and the home. So she really doesn't, if she committed this crime, doesn't need to be a parent, in my view. How often does a seat for a judge open to, was hoping SKD? Well, that's a good question, postpartum. Sarah Catherine certainly is qualified to be a judge. She's got the experience, the knowledge. But right now, there's two ways to become a judge. You can run for an open seat, or run against a judge, or you're appointed by the governor. And the governor they have judicial nominating committees, and they nominate them, and then the judge or the governor interviews them, or his people interview them. And the governor takes into quite a bit in determining who he appoints. And it's not always the ones with the most experience. I think a lot these days are going by your judicial philosophy. And I would think that Sarah's philosophy would be in line with the governor. So she can always apply for another judgeship, or she could run for a judgeship. So, but she didn't get the last one. And she's young enough that she still has an opportunity to become a judge. It's delayed to 12:08. Thanks for being here, and you. Thanks. Thankfully, the kids are with the victim's sister, apparently doing well given the circumstances. Isn't it always the kids that are always the victims in these things? And I know we've talked about Dan's kids being victims, and I guess you can never understate how much of a victim they are. And they're going to be victims for the rest of their lives, right? Because when they get older, they're going to know that what happened. They're going to find out. The way social media is today, they're going to find out what really happened, who did it. And you pretty much realize then that you don't really have a family you can be proud of, that you can trust, and you lost your father. She wrote a book, and she wrote a book like Wendy wrote a book. All these people writing books. Maybe that was a catharsis to get over her guilt feelings. I don't know. She wrote a children's book about kids and death. Well, she should have thought about that before she allegedly committed this offense, right? And I don't know if she did or not, but the state of Utah believes she did. The state of Utah believes there's sufficient evidence to charge her with first-degree murder. And if she's convicted, then that book is just, appalling that she wrote that book. And I feel bad for the kids. Feel bad any kids that are victims. Yeah, the cover-up usually is worse than the crime. People do things that usually end up getting them convicted. People go back to Watergate. The cover-up was worse than the crime. A lot of crimes you see today, people cover things up and they get more in trouble for covering it up than the crime they did. That's because they got a guilty conscience, right? And that guilty conscience, they can't help themselves. And like her going on there texting, just like in Karen Reed case, right? They were going on there texting how long before a person freezes to death. There are a lot of questions about when that was done and when that search was done, but why would you do that? She had a ghostwriter. Well, of course she had a ghostwriter. Do we really think she was going to write a book? And depending on the book, I haven't read the book, the state may find evidence in there, something in there that they can tie to motive or guilt to introduce it. Or they could possibly, if she testifies, find something in there that's inconsistent with what she wrote in the book. Remember, Wendy's book was pretty illuminating and was used also. There were things in there that clearly showed that she hated Tallahassee and she was trapped. Yeah, people often tell on themselves, or they tell other people that they shouldn't. They talk, and like this case, she hired the maid or someone to get her drugs. That's a witness, and maybe that witness is got criminal history. That's fine. The question is not, is that person a good witness or not telling the truth? The question is, can you believe what she said, and does it fit the piece of the puzzle that the state is showing? And it does, right? If she said I sold marijuana to her, that's not relevant because he didn't die of marijuana. But when she says I got drugs for her 2 occasions, and the second time, but I said it's not really fentanyl, you don't know when you're buying drugs on the streets, right? And today we see a lot of kids overdose. They think they're buying one drug, but they're laced with fentanyl, and they end up overdosing and dying because fentanyl is put into so many different drugs on the streets that the person saying, I didn't give her fentanyl, they don't know if it's fentanyl. They don't know they gave drugs to Kouri. Kouri gave them to him, and he died. That's enough. That is enough, in my opinion, that a jury will convict her if that testimony comes in. I think Miss CC, they're covering another hearing on one channel, and I'm doing this channel. So we're glad you're here. Joe and on from Nikki Reiner live. Yeah, they're going to switch over here, Miss CC, and I'm carrying the ball until they get here. And hopefully you can stay with us, and hopefully we'll get the show started, hopefully in like 8 minutes. Yeah, people often think they can get away with the perfect murder, and there really is no perfect murder anymore. You got that phone, geo-tracking phones, you got DNA, you got social media, you got Snapchat in the South Carolina where Murdaugh said he didn't go down to the kennels, but you got his son was doing a Snapchat and you can hear the dad talking. It's funny how people don't plan everything. And today, now it's so difficult. Cameras are everywhere. Everywhere you go, there's a camera, and you end up getting caught because of technology. Because very often technology catches you. And that's what happened in the Adelson case. You're the only parent the kids need and believe you're so smart you won't get caught. She Wolf, that's right. It's best for everybody to have 2 parents. You got male and a husband and a wife, and gives the kids a family structure. A lot of times the boys are closer to the mom, the girls are closer to the dad, but they're all a family unit. Not everybody has that, and it's not necessary to not be, but it also helps financially to have 2 parents. Sometimes single parents financially struggle. Miss Cece, I don't know how that's working, how you can be on 2 channels. That's above my pay grade. But I know that they're doing double streams, and when the Reiner trial is over, they're going to come here, Joe and Joel, and hopefully everything will work without a glitch. And if you're watching the Reiner trial, you can come over here, and if you're waiting for this one, you can just hang on for 7 or 8 more minutes. So if you have any questions about this case or another case, I'll be glad, or any legal issue that you want to discuss, please put it on the board in the comments, and I'll try to answer your question to the best of my ability. Hope everybody's having a great 2026. It's funny saying that, 2026. Hearing is delayed, but should be starting in a few minutes. So stay tuned. We're going to have a hearing. We're going to discuss it. It's an honor to have you on the show, Rosie. Thank you. It's an honor being on the show. I enjoy it. I really enjoy when I'm in somewhere like Publix, or I was with some friends in St. Petersburg, and I ran into a woman came up to me and watched the show. And I get that a lot, people that come on and watch the show. And it's really nice hearing from the listeners and subscribers. And they're very kind. And, they usually ask one question. Of course, the one question is always about Wendy. I've given my opinion on that. And I don't think time is going to change that. But everybody wants to know about that. The year did fly by. 2025 did fly by, and here we are, another murder case with young kids that are left to fend with one parent or maybe no parent. And hello, South Africa. Hello, Happy New Year. I hope everybody had a good New Year's. Unfortunately, Tallahassee had our first killing, like January the 3rd, another shooting the other day. So it's sad when they start counting, okay, the first killing of the year, that we've gotten to that point in any society or any community, because someone has lost their life. But these kind of things here, spouses murder, they're becoming all too prevalent. And these detectives, they know what they're doing. When they see a spouse, someone dies of unnatural causes, the first thing they look at is going to be the spouse. And that's their first objective. Who has motive? Who gains from it? And I know there's a case in Ohio now of a dentist and his wife were killed in Ohio. And I know that that's kind of a new case, and they're still trying to investigate that. It'd be interesting. Someone sent me a text, asked me if it was ex-spouse. And I don't really know much about it at all. Don't know anything about the case. But it didn't sound like they were robbing anybody or stealing anything. So it looks like somebody had a reason to target those people. Hopefully the law enforcement will find out and the perpetrators will be caught. I hope everybody's warm up north. I know it's been a cold winter. Massachusetts, where we have a property, has gotten a lot of snow this winter. I know New York and Buffalo, and it's gotten a lot of snow. And they were anticipating this. I remember this summer, they were saying we expect a cold, snowy winter this year. So the prognosticators were correct. We've only got 5 more minutes, so if you have any legal questions. STS is great. Joel does a great job. He really does. Consummate professional. He keeps all the guests involved. Very positive. That's from his journalism background. Yeah, it sounds like it was targeted, that killing in Ohio. The case Sarah Patrick, do you think this thing? I don't know the case Sarah Patrick. You don't normally would put a 5-year-old cannot testify in most jurisdictions. They're too young. So I don't know where that jurisdiction is. A 5-year-old. In order to be a witness, you have to be a competent witness. You have to be able to tell the truth, understand perjury, but telling the truth. I don't think a 5-year-old is sufficient. Sometimes they get child hearsay in sexual batteries in Florida. A child will be interviewed by a professional and they talk about what happened to them. And that is admissible in trial against the defendant. And you don't subject a 5-year-old to a cross-examination. But I don't know of a 5-year-old actually being on witness stand. Who would cross-examine a 5-year-old? How would you do that? That would be very difficult because you're going to come off bad cross-examining a 5-year-old. You can never. I mean, I guess you have to be really polite. A paralegal certificate, is it worth it? What can I realistically expect to do with it? Well, cannibal cupcake, it depends where you live. Okay, so court lurker, a Georgia case, 5-year-old found parents shot in their bedroom, 17-year-old daughter due to go to trial in August. Now, I guess it'd be interesting. A 5-year-old could identify a sibling, right? And say, yes, my sister was in the room, and that's all they can testify. Who was home when you found, oh, my sister was home? That's testimony. That's giving eyewitness. That's a direct witness that somebody was there. I don't know if that would be admissible, but that's interesting. I would think that the state would be able to say, Judge, we're calling this person for the sole purpose to say, who did he see in the room at the time of the killing? And he's going to say his sister. Teacher confidence, everybody's getting a paralegal certificate. You know, you can go work in a law office if that's your interest, and you can gain so much valuable experience without a paralegal degree. And then you can see if that law firm or wherever you're working at would give you more pay and more responsibility if you get a paralegal certificate. That might be your question. If you really want to do paralegal work, a lot of law firms hire people, and you might do an entry-level job and then move up to another job where it's pretty interesting. If you're really interested, you can do it. You should do it. If it's something that drives you, that you want to do, you should do it. South Africa is a very dangerous country. Most of all the homes are fenced in, dogs, cameras, burglar bars, even inside the homes. Well, that's too bad. Tim, is it normal some jails, prisons do not have any visitations for anyone, even more? That, howdy, MQ, it should not be normal. It is not abnormal. COVID was really bad. We sometimes have hard times, even as lawyers, getting in past 8 to 5. And if it's the federal prison, we have to leave like by 3 o'clock, which I think is a violation of the Constitution. And I know some jails are more lenient. The smaller jails give visitation. It depends on who's running the jail. I've got some jails that's very easy to get into, and I got some that it's rather difficult. It's frustrating. I know that. Someone waiting trial should be able to get visitation from family members. Now, they limit some, like in federal, you can't go in there if you're a convicted felon. You got to be approved. You can't be a co-defendant. You can't be a witness in the case. You can't be under investigation yourself. You can't be charged. So there are limitations, but I don't think they should allow a person not to get a visitation within a year. I think you should have a basis to file a motion with the court that it's unconstitutional. That's my answer. But do they still have video? We still have in-person visits. I know the jails here do video visits and in-person. I saw them the other day. It used to be was just video visits, but now they have in-person visits. They're limited to like 30 minutes. If you go over the 30 minutes, then you get suspended. So Teacher Confidential, if you want to get involved in the legal world after, if you like crimes, I can tell you that if you go and say, I want to volunteer, get a good law firm, a good defense law firm. They do criminal defense. And you say, hey, I just want to volunteer. I think if you do good work and volunteer and you do well, then you'll get paid, then you get put on, and then you can learn stuff. And if you can help the firm, they might give you you might not even need a paralegal certificate. You might enjoy doing the work without that paralegal certificate, even if you're retired. Now, if you have to work to get paid in retirement, I think then I don't know if you really need a paralegal degree. I've had paralegals with degrees. I've had some that worked their way up. I've got mine forever. She's wonderful, but they can all assist, and it depends on what responsibilities you're allowed based on your training and experience. My cousin has been a paralegal for South Florida, I guess, law firm for years. She loves it. Great profession. It can be, and I will tell you, I've seen lawyers that do not treat their staff well, and I think that's a mistake. I think lawyers should treat their paralegals and any staff with respect and as a family like we do. And I won't tolerate any lawyer treating a paralegal or an assistant, secretary without the due respect, because you're a team, and so I hope that they like the profession. It sounds like they treat him pretty well. And San Francisco. Okay. Well, we should be starting. It's 12.
Good
morning, Your Honor. Brad Bloodworth, Margaret Olson, Lindsay Shervanack, and Fred Burmester for the state.
Very good. For the defense.
Wendy Lewis, Catherine Nestor, and Alexander Ramos for the defense.
All right. Counsel, as I understand it, we're here today to address the defendant's motions to exclude 3 of the state's experts. Is that correct, Ms. Lewis?
Yes, Your Honor.
The states recently filed a motion to exclude one of the defendant's experts not on the list for today. We'll address that in some fashion in the future. Yes?
Yes, sir.
Okay. Ms. Lewis, do you have a plan on how you want to proceed?
Your Honor.
It's the preliminary matter. My apologies.
Just thank you, Your Honor.
Of course.
Your Honor, the state wants to ask the court to make additional findings in connection with its order from yesterday denying the state's motion to determine admissibility of evidence. The court's findings regarding the defendant's financial crimes as it relates to the state's pecuniary gain element argument is clear. In its briefing, the state raised 2 additional arguments that the state asks the court to address. The first is that the defendant caused Eric Richins' death to cover up her financial crimes, and this proves an additional motive as well as the identity and intent elements. And the second argument is that the defendant's...
I'm sorry, no, I just am having trouble hearing. I need you to pull down the mic. Thank you.
And the second argument, Your Honor, is that the defendant's financial crimes show that causing Eric Richins' death was her last resort, and this proves the identity and intent elements. The state asks that the court make intrinsic evidence findings on these 2 arguments and additional findings under Rule 404, as these additional arguments increase the probative, in the state's view, increase the probative value of the financial crimes evidence. Finally, Your Honor, regarding footnote 3 of the court's ruling, the state asks that the court note that the state advanced its complete the story argument in its moving papers before Blackwing issued, and then in its reply papers revised its argument to comport with Blackwing. Thank you, sir.
Yeah, let me be clear.
Yeah.
I understood your arguments. I just didn't find them persuasive. The state simply hasn't carried its burden to show a sufficient or persuasive basis that the arguments you just described satisfy the legal standard for intrinsic
Sure.
or provide a sufficient or persuasive basis to avoid the court's view of the balancing of the propensity inference that is most likely to be drawn under 404B, which implicates the 403 analysis the court made.
Your Honor, I appreciate that. And I don't think that comes through in the ruling. I think the ruling very clearly and specifically addresses the pecuniary gain. And the court, may have built in its thinking as to the other two of the state's arguments, but I don't know that that is reflected in the ruling. And I think it would help if it was.
Okay. I understand your position.
Okay. Thank you, sir.
Anything else on a preliminary basis?
No, Your Honor.
Okay. Very good. Ms. Lewis, my apologies. No, it's okay. You can sit down. Oh, go ahead.
Your Honor, I did want to ask, can I move in and out of the courtroom as business requires?
Out of the well or out of the courtroom?
Both.
Yes, that's fine.
Thank you, sir.
Thank you. Ms. Lewis, we're here to talk about 3 experts. Happy to handle those in any particular order. I'm happy to have some legal argument and colloquy before or after taking testimony if necessary. What's your view of what the defense needs to do today?
Well, we're handling different experts, but if we could maybe handle Ms. Amon and Dr. Fox first. I think that if Ms. Amon were to testify and then Dr. Fox, and then we could handle that. And then Kathy, you're doing
The other two.
and then Ms. Nestor's doing the other 2. So I don't know if you prefer an order on those. So either order on the others.
And forgive me, with respect to Dr. Fox, nobody's challenged her.
No, she's going to testify if the court needs to hear it about the scientific reliability of the pathway to violence and why it should be excluded as under 702. Based on her
Let's talk about that structurally.
Okay.
If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than admissibility?
Absolutely.
Well, possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on Ms. Amon first.
May I just briefly address the court?
Sure.
Then Ms. Sherbernack will address Amon.
Okay.
Your Honor, because it's the state's belief that the defense has not even met its minimal requirements under Rule 12.
To do what?
That they specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the papers sufficiently address the threshold showing. As the court is well aware, after Ramash, after cases like Clopton and Gunn-Hildary and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through, it sort of flipped it upside down so it catches almost anything. And even if there's 2 witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers, the state believes it has met its burden of a threshold showing. Now, the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other two are on the line. So if the court wishes to proceed on to specific questions about Ms. Ammon, then Ms. Shervanak can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each witness's testimony. So the state's argument regarding the insufficiency of the defendant's initial briefing is respectfully rejected. I have specific questions regarding each witness within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. So whose witness is Ms. Ammon?
Ms.
Sure, I can ask you some questions.
Of course.
You just got to pull that mic closer to you. Okay. In its brief, in opposition to the defendant's motion to exclude Ms. Ammon's testimony, on 2 occasions and in bold print, the state says Ms. Ammon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Ammon testifying? Is it in the state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me, that in the state's view, Ms. Ammon's testimony may be helpful to the trier of fact to rebut an argument that, hey, this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husbands. And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence, but this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part,
Okay.
I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Ammon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an analytical framework. And again, Ms. Ammon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She will not be saying Ms. Richins, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Ammon will not be saying Ms. Richins fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Ammon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
Sometimes, right?
well, yes, but also Ms. Ammon could describe that in every targeted act of violence, and this is part of her proffer, that there is a framework, a pathway to violence that perpetrators of targeted violence follow. Now, do they complete a couple steps and pause? Do they all follow the same timeline in the exact same sequence? Maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack. And all of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke some questions regarding the Diaz versus United States case that was cited in
Sure.
defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said there, the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And the United States, a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not a implication regarding the defendant's mental state or what was in their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question. I mean, and she can explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I don't think that's what Ms. Amon's testimony would be, but I would rather not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will? Yes, those people exist. And Ms. Amon would not know who those people are.
I read her proper. She seems to explicitly acknowledge that people stop at various points
Right.
along the pathway.
That's my point. So
Okay.
to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always. No, that's not her testimony.
Okay.
And that's not factual. But for her to say in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result. The attack has occurred. We can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay. All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sherman?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, yeah, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point, and
Is it cited in your brief?
no, because I didn't know about it.
Okay,
It's
can
something
you give
I
it to me?
just discovered.
That's okay.
Anyway, it is United States versus Wells. Let me give you the site. 879 F3rd 900. And that case was also a blind expert who is actually one of Ms. Amon's colleagues in writing the profile for violence. And his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And there's also, and yeah, I'm sorry, I actually just found this case yesterday. But there's also a 403 and 404B argument, because the way this works in courts when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using the precursor to the profile for violence. It has very much the same criteria. It has been modified since then. This was in 2017. And he did a profile of killings in the workplace. He was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z. So therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like, I've looked at Ms. Ammon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be missummarizing here, but there's a higher level to it. And when we look at Diaz is even more specific, and somehow the majority of the United States Supreme Court is like, yeah, they said most, not all. So the jury, the trier of fact can draw distinctions. How do I apply Diaz to Ms. Ammon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
That is one you cited.
I know it
Yeah.
is, and I did not reread that case. So I would actually
We can we'll take a break at some point.
need
We
a
can
moment to
compare.
review that, to be frank.
Okay, Ms.
But-
Sherbinet.
Oh, I'm sorry.
Oh, okay. Yeah.
I do think that it would be helpful to hear Dr. Fox's
Sure.
testimony. For one thing, this routinely isn't used. It's used at NBAU as an investigative technique sometimes,
Right.
but it's not used in the courtroom. And that's because of all these problems that Dr. Fox is much more qualified to address than I am in terms of it's junk science is what it is. It's not scientific. It's not used in the community. And I think that does stop it even under our low threshold here.
Well, hold on, but come back to the specific context of this case. The state has noticed Ms. Ammon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness to the effect of, this is not the way it works. This allegation that Kouri Richins killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Well,
Now, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Ammon.
I think we're going to need some clarification beforehand. If Ms. Richins testifies and testifies that she did not do this,
That denies committing the crime.
then how does that not open the door for them to say, well, of course she committed the crime because she's on this pathway to violence?
No, I don't think they get to do that. That would be more like profiling.
Okay. I still have the whole 702 problem no matter how. And this is the first I've heard it's only going to be used in rebuttal. I think we would actually use less time if we let Dr. Fox
Happy to.
go through and explain the problems with the reliability of the science and then go from there, if that's all right.
Sure. Ms. Sherman.
The only points I wanted to make, and the court has has honed in on this, but in Dr. Fox's declaration that was submitted as an attachment, she analyzes the federal rule 702 and why Ms. Amon's proffer does not fit within that. There are fundamental differences between the federal rule and the Utah rule, and I don't believe that it's helpful for the defense's witness to make a legal analysis about whether Ms. Amon's testimony does or does not comport with Rule 702. That is for the court to do. So
I agree, but I can sort that out.
And Dr. Fox is familiar with the Utah Rule 702 and is prepared to address that.
Well, yeah, but I don't need her to address the law at all. I just need her to tell me her view.
I understand,
of
but she hasn't now analyzed it under the Utah law. All right. Would it be all right if we go forward with Dr. Fox?
Sure.
All right.
Dr. Fox, good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can see Ms. Lewis.
Good morning, Dr. Fox.
Hi, Ms. Lewis.
So could you just please state your name for the record and tell us what your current position is?
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you... Oh, did you want to swear her in? We didn't do that.
Yes, thank you.
Thank you.
Dr. Fox, would you please raise your right hand for me? Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tax. I went to the University of Florida to earn my master's, and then I earned my PhD instead of my JD from the University of Cambridge in England. My doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with threat assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Amon, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division, and in between there, I worked with the Tampa field office in the field of investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly, you talked about that you worked with the BSU, and I know Ms. Amon has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy. That's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over in the research arm. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology, law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
Okay. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment through my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts, in a legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then tried to help improve the scientific validity of both profiling and threat indicators, is what really motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessment, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said she isn't.
Okay. Just wanted to make sure as we move forward. All right. So are you familiar with the pathway to violence model?
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
All right. And is it designed to diagnose or predict whether a specific individual will commit violence?
Again, no. It's a subjective, group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. It applies sometimes, but in other cases, it doesn't apply. So we really have no idea how often that occurs. It applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Zoom.
Well, group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's behavioral science unit, the infamous, organized, disorganized profiles, they were created just by thinking about what we see sometimes in cases. And sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested. You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, that's one person's opinion. There hasn't been a scientific evaluation of this to actually say this often it applies, this often it doesn't. There's no known error rate. There's no accuracy rate. There's no reliability measure. It's just a, guess.
So that's why it's important in a legal framework that the pathway to violence is descriptive framework and not predictive. Yeah,
it's descriptive. It would be like saying that both of us are female, and females are more prone to, I'm trying to even think of an example that would be kind of as like detached from the data, but we could say, well, both these women would, engage in, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two, people that, our judges seeing today, both are in a courtroom, that doesn't mean all women are in a courtroom. The example I use in my undergraduate course, every person who went to the moon eats chicken. That doesn't mean that everyone eats chicken goes to the moon.
All right. So does the pathway to violence, does it tell us how likely it is that someone will engage in violence?
No, that's a major flaw of it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think the major, I keep on saying this, another major problem I have with this is there are lots of people that have those grievances. I can name like so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence, or they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, out of a larger group and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the pathway to violence model is doing, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on, our thoughts. It's not even based on their analysis of data.
All right. So addressing the reliability and the 702 standards, has the pathway to violence been published in peer-reviewed journals?
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I've researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I am aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You can write whatever you want as long as the publisher agrees to print it. You're good to go. In Ms. Amon's proffer, the pathway to violence model was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like I'm mean, but that's a predatory journal. They write to me often and ask me if they can publish whatever I want in that journal. It's not like a legitimate, valid journal. And that paper that was published in the Journal of Forensic Sciences, it wasn't even about the pathway to violence model. It was about political assassination in the United States. The pathway to violence model was mentioned. It wasn't even a study of the pathway to violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
When discussing reliability, why is it important? I asked this, I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that, stamp of approval if it's not reliable and valid. I mean, that's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the Pathway to Violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody what I determine to be a grievance could be different than what Ms. Amon thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say, that fits, and there's subjective interpretation behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
All right. So different evaluators could look at the exact same fact pattern and come up with opposite conclusions. Is that fair?
Yes, absolutely. Because there is no standardized criteria for what these things mean. They're barely even defined because again, there's so little peer-reviewed papers even discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these side areas. So an example of this would be two evaluators could use the Pathway to Violence model and can reach opposite conclusions, and there's no way to determine who's correct.
Okay. So is that consistent with things that are admitted as being scientifically reliable?
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is if you have two people stand on two scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on two scales at my gym and at my doctor's office and there's two different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day and all of a sudden you're getting different results, it could mean your weight has changed, but if it's 2 times in the same day, probably not. It means your scale is broken. So, this model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, inter-rater reliability is basically this idea that if two people use the same construct, will they get the same result? And if people are having the same scale, implementing it and get different answers, it's not reliable. And it just has a basic foundational level. So you would want the same instrument applied and to get similar results. So two people should be able to look at the same case and have a general agreement that this person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect. Inter-rater reliability, that's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the inter-rater reliability on the Pathway to Violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say, I think this person, or this is what tends to occur on the majority, that somebody would be on this pathway to violence. You have no idea how often that happens. You have no idea how often you're wrong. You could say that is the case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem for in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right. Is there any scientific data showing how often? I'm almost done, but I'm sorry, what?
Oh, I didn't say anything. My apologies.
Oh, okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and without overemphasizing this, there is no reliable data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on the pathway to violence. That was literally the task I had. I was the person who did it. And this was in 2000. The first time I started on it was 2010. And then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I've been finding, I didn't have the resources to really complete this in the way it should have been done. And it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong. We just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh, it's not based on any data. It's based on, I teach a forensic psychology course. And so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right? But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition, educated guesswork, and hunches. And so I always teach my students, that was the 70s way, but we're doing this differently now. And the pathways to violence model was developed in that same approach. Educated guesses.
Okay. So Ms. Amon, and I suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offense has occurred to then go back and use the pathway of violence model?
No, that's like a basic logical fallacy. That was probably on your LSAT exam. You can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, that actually, there's the pathways to radicalization. We've, toyed around with this idea. They've all been kicked around and kicked down. But that one was the pathways to radicalization profile. And it was this traits shared by attackers. They're young, male, Middle Eastern, and you could say, looking at, the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Literally it goes down from, everybody who, commits terrorist attacks fit this profile to 0.00000, I don't even know how many digits out, 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalization? There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, all the people fit that. Not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them just without even having 1% accuracy rate.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw. By implying these group level descriptives, you're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. They, go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their, situation. They even may say, I'm so stressed, I'm mad. They will never go on to commit violence. This is an extremely rare base rate event. And low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, like as an American taxpayer, I feel very concerned by that.
So let me ask you, you heard the discussion before you testified about if Ms. Amon were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because, if we were that good at predicting violence, I mean, think about the problems we have when we're talking about parole. We're talking about, risk assessment, when we're looking at releasing people. We're doing, my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior, because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence. I could actually, look that up in a couple of minutes and tell you what the base rate is. But because this pathway to violence model has never been evaluated, anyone who would say, here's what I think, they're just guessing on how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose, if it doesn't actually ever predict who will go forward to commit a violent act?
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting, looking at this, putting very sophisticated predictive models together, we are so unable to predict violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than, any type of, long-term grievance, at least based on research. If we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy, because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh, no. And that's actually, again, something I talk about in my undergraduate courses. We have this problem, it's like mission creep. We think, because it applies here, it can apply over here. And that's absolutely not the case. A domestic violence type of scenario, poisoning, they're so fundamentally different in the way those two things are committed, played out. Applying something that is even without data created for the purposes of these targeted attacks that do engage in more radicalization behaviors. You applying that to something that's statistically more emotionally driven, that would be very inappropriate.
All right. So just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence that a jury can rely on?
No, absolutely not. If we're basing this on reliability, if we're basing it on, how using it to know that this is scientifically valid, absolutely not. The logical fallacies that are endemic to this, the huge amounts of unknowns, like how often it's wrong, which would be far more wrong than right. It's akin to like the Barnum effect at circuses, or like psychics. That would be the closest, I would say, in terms of how accurate and valid and applicable this would be to an individual case.
I have nothing further.
Ms. Shervnak, do you have any questions for Ms. Fox?
I do.
Ms. Fox, may I ask you just a couple of basic questions?
Surely.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
No, I wasn't. There are these, similar models, like, I think they call it like pathways to radicalization. And I just learned about that. And again, like while I was in the BSU, that was one of the things that I was brought on to try to revamp and improve.
Okay, thank you. Ms. Lewis, anything further?
No, Your Honor.
Okay. Ms. Shervnak, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
Thank you.
He certainly is very confident, and I don't think
Ms. Lewis, do you want to ask any questions of Ms. Amon?
Are you not going to put Ms. Amon? Is the state going to put Ms. Amon on, or only if I have questions? I guess would be
Ms. Shervnak, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from you.
Okay. Ms. Amon, do you mind turning on your video and audio?
Okay.
May I swear you in, please? Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
Good morning, Ms. Amon.
Good morning.
Your Honor, before I begin with her testimony, Ms. Amon's CV lays out her qualifications. The state's position is that she possesses the requisite knowledge, training, experience, education to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I prefer to focus my questions directly elsewhere. If that
I
makes sense.
agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor. So, Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears. They vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. It's affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localize sound, and the cats would inch forward. And they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades,
Kouri finds
the
it
line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, there was really no time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived. In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did not do that were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of the studies, many studies. So that's kind of a 10,000-foot view of the science in terms of how we got to where we are now.
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m. But what I can tell you is that you're at heightened risk for a cardiac event, and we need to manage your condition with lifestyle changes and probably some medication to lower that risk. That's how we work in behavioral threat assessment, and the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do. We would begin to look at the behaviors the person is demonstrating, and our being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure. That is behaviors that raise for us concern about whether or not violence might be on the horizon.
And is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, you still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple. Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant. What's relevant is that certain behaviors must occur in most cases in order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Is the pathway to violence model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a past a model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation, it's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
And now, if you could explain the retrospective analysis and why prospective analysis is not feasible.
Sure. All the studies on pathway and proximal warning behaviors are retrospective. And in fact, someone asked me at a conference the other day, where are we on prospective research? And my answer was nowhere. We can't do it. So retrospective analysis is looking backward at cases with a known result. So violence. So let's say I want to look at a single person homicide in a workplace. I would look backwards at the completed event, knowing that it had the result that I'm interested in, violence. And then I would look for what patterns of behavior can I identify that did occur leading up to the violent event, and then code those. And so I would know that those occurred. So a retrospective study would have a sample of cases and then look backward in time and code the behaviors that we know to have occurred. And that helps us to understand what are the commonalities. You can't, Dr. Fox is absolutely correct that those studies can't be used for prediction. They're not predictive validity studies, but what they do is validate the measure as measuring what we intended to measure. Prospective is, you would need a prospective study to truly call something predictive, but to do a prospective study in violence would be to have a case of concern, and then look for what you believe to be pathway behaviors. And once you've identified them, it would require you to sit back and do nothing and allow violence to unfold and then code your data, which is horrible to even think about. None of us would ever do that. So we use retrospective analysis, and it's widely acceptable in the behavioral sciences as a research strategy.
Thank you. Just a moment. Those are my questions for you at the moment. Thank you.
Well, I think the judge sees the behavior of the defendant. It's obvious. The judge is looking out. What is the only thing he looks at are the witnesses, and he looks at the participants, and especially the defendant. He sees her behavior, and it's going to come back to haunt her. I think this witness did a pretty good job limiting what the relevance is going to be on rebuttal.
Good morning, Ms. Amon.
Good morning.
So Ms. Chervenak asked you how the model was developed, and you told us about cat research, but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people. And in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became the pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time. And so that became the pathway to violence. Does that answer your question?
A little bit. So, but the pathway to violence talks about, well, strike that. Let me rephrase. So you used the analogy of a cardiologist. You said this isn't predictive, it's preventive.
Right.
Right?
Right.
So this only applies after an event has happened?
No, not at all. That's how we have studied it. How we use it is in advance. So let's say, for example, you are a school principal and a child in your school has risen to your attention as raising concerns for violence for whatever reason. Maybe he's got a hit list, maybe he's stalking his girlfriend. So I would look at that if I were consulting with you, and I would ask for everything you know about the situation and the child. And I would look for evidence of these 8 proximal warning behaviors primarily that we know to be well correlated with subsequent violence, including the pathway. And if I saw evidence of any of those, then I would advocate for active management of the case to try to reduce the violence risk. The general rule is that once you observe 1 or more of the proximal warning behaviors, then some sort of active management is necessary to prevent violence. So we're managing behaviors of concern in the present to prevent violence in the future. We don't know that the child is ever going to be violent, but we're not waiting around to find out. We're going to take active steps to try to prevent and manage.
And you have no idea if absent those active steps, would that child ever have committed violence, true?
No idea is a bit strong, but do we know? No, we don't know. That's correct. Someone can certainly ride the pathway all the way up to one of the upper steps and then never do a thing. That's entirely possible.
All right. So you talked about that it has been subject to many studies. Could you tell me what studies this has been subject to?
Sure. I was a little bit surprised to hear Dr. Fox say that it has been subject to no studies. The most recent study that was specifically on the pathway and only pathway came out in 2024 in the Journal of Threat Assessment and Management. And they had a very high, actually high inter-rater reliability score in that study. I would say the majority of studies in the last decade are more on proximal warning behaviors is the label that you would have to search by rather than pathway. They're on, almost more than I can count. Public figures, mass attackers, intimate partner homicide offenders, other sorts of family offenders like paternal filicide, maternal filicide, that kind of thing. Workplace, classroom. The journals are really littered with studies looking at proximal warning behaviors.
Are there any peer review studies that you can point to that adopt this?
All peer reviewed studies, all of them.
What are they?
Well, I supplied a list to Ms. Chervenak when they first contacted me, but the most recent one that I mentioned in 2024 is called "Are All Pathway Behaviors Observable? A Quantitative Analysis of the Pathway to Intended Violence Model." And that came out in the Journal of Threat Assessment and Management.
So the same one you just told me about.
Yes.
Okay. All right, so it's not a predictive model, it's a preventive model. It's not capable, you can't generate any numerical score, correct?
No.
Using this. And it's not designed to determine if a specific individual is going to commit violence, correct?
No, I agree with Dr. Fox's description that it's a descriptive model. It describes behaviors that have been observed in studies. I would say its operational use is not in prediction, but in prevention, which I think is really a key difference in terms of how we use it in the field.
So it could be useful if someone came to the FBI and said they're thinking about a mass shooting.
I'm not sure I take your meaning.
Well, if it's not useful in predicting violence, and it's useful, as you said in your cardiology example, if someone comes in and says, hey, I'm having these symptoms, then, you can help prevent it. So how is this at all useful in the real world? Because people don't come into the FBI and say, I'm having these symptoms. And you can say, well, you are on the pathway to violence. Let me help you. That doesn't happen, correct?
Yeah, that's never happened as far as I know. But how it is used is if I'm looking at a case where someone has already risen to the attention of whoever is observing as someone being of concern for violence, maybe they've been making threats, maybe they've been menacing people, maybe they have a hit list, whatever, that can look a million different ways. Then I look at the entirety of the case, as many facts as can be gathered, and then I begin looking for signs of proximal warning behaviors to decide if we're in, sort of an imminent countdown potentially to an act of violence. And that's where the pathway to violence becomes quite useful. If I observe someone on the pathway, particularly in late stage pathway markers, then I might develop, depending on the context, I'd have a lot of questions, but I might become very concerned that we're close to a potential act of violence.
Has this ever actually happened in the real world, where you have stopped violence based on something that was brought to your attention?
Well,
how can you say that has happened?
We can't. That's what I mean by there's no prediction. I can't. So when we see pathway behaviors or other proximal warning behaviors, we intervene. That's our job, is to intervene. So once we've intervened and there's no violence, how can we ever say that there would have been violence but for intervention? You can't. You can't prove what never happened.
All right. It's fair to say that two evaluators could look at an individual and reach completely different conclusions, whether someone's on the pathway to violence or not, right?
Not well-trained evaluators.
So your testimony is that people always come to the same conclusion if they're trained in this?
No.
Okay. So people can come to different conclusions, even if they're both well-trained people?
I think if they're well-trained, they should not come to different conclusions on something as fundamental as the pathway. But it can come to different conclusions about how close someone is to violence.
But it's subjective, right? It's not based on scientific data.
Well, it is based on scientific data. All those studies that I referenced in the 80s and 90s that helped Brian Foskule, Randy Vorum, and Robert Fine arrive at the pathway to violence. That's data.
The journal we talked about that it was published in.
No, that's a different journal. There are dozens of studies, but we're talking about the study I referred you to was in 2024, just because it's the most recent one, specifically on the pathway and only the pathway. But the journals I'm talking about we're talking like 80s and 90s.
There's no way that the model can tell us how often it produces false positives, right?
Correct.
And you can't tell us the model's error rate. True?
Correct.
You can't quantify the likelihood that an individual identified as being on the pathway will not commit violence.
I can't quantify whether they will or will not. It doesn't work that way.
Yet you believe you could apply this framework in this case?
I don't know anything about this case, actually.
Well, you know what the defendant's charged with.
I believe it's a homicide, but I don't know any facts and circumstances or if there are other charges.
Okay. Are you familiar with the case United States versus Wells?
I am not.
Isn't Agent Malloy a colleague of yours who helped write The Pathway to Violence?
Agent Malloy? Oh, Dr. Reed Malloy?
Yes.
He's not an agent. He didn't write The Pathway to Violence, nor did I.
So you're not aware, you gave the example of workplace shooting.
Okay.
So you're not aware that that is the exact case that was rejected as the science being unreliable in the United States versus Wells. You're not aware of that.
I'm sorry. I have no idea what you're talking about.
All right. Have you testified in a homicide trial about the pathway to violence previously?
I have not.
Have you testified as an expert previously?
I have not.
Can you give me any examples where the pathway to violence was used in the courtroom at a homicide trial after the fact?
I don't know.
Okay. I have nothing further.
Is Sherman anything further?
No.
Okay. Ms. Ammon, thank you. You're welcome to turn off your video and your camera. Why don't we take a 10-minute break and then we'll come back. Thank you. Come back at 11:10. Thank you. Court's in recess.
11:10. So
Yeah.
I don't know what clock he's looking at, but my clock doesn't go to 11:10, 10 minutes. But so it's interesting here. So you have two experts, and as he said earlier, what you'll hear in all evidentiary rulings in courts, the key word is a rule 403. That's the primary one you always hear. So that means any evidence that's admitted under any other rule has to always go through what's called a 403 analysis. So if you say something's a hearsay exception, it still goes to a 403 exception. The final filter is 403. And that's what they mentioned earlier, 403. 403 is a balancing test. It's the probative value, how valuable, versus the prejudicial effect, right? So the judge has to make a determination that any evidence that's going to be admitted under any rule has to pass through 403. The judge does that balancing test. He determines, okay, I think this can assist the juries, and I think it's not so prejudicial, I'm going to allow it. And that's what he did in this case. He talked about, okay, these two experts, why don't we just let both experts come in, and doesn't it go to the weight of the evidence, not the admissibility? The defense is arguing, no, this is what she said, junk science, shouldn't come in. Now, Rule 702 of the Utah Evidentiary Code is what's called a modified Dahlberg. It's not the federal case that they've been citing and the Ninth Circuit case that they've been citing. The Ninth Circuit is a federal court, a very liberal court. And in fact, whenever you cite that, depending on where you are, some judges laugh at the Ninth Circuit, especially in the South, which is more conservative. So complying it to the federal rule in that federal case has no relevance because Utah has a less strict standard introducing expert testimony under what's called 702. 702 basically has to be reliable based on some sufficient data and reliably applied to the facts. The first expert, Dr. Fox, very confident, let you know everything she did, who she taught, what she did, which is fine. Came across as a little arrogant, a little dismissive of people that disagree with her. I think she tried to give analogies, but she didn't give very good analogies that a judge or a common person could understand. She basically saying, I did everything, I know everything. And I think upon cross-examination by the judge, he tempered her. Well, you really didn't do this when you were at the FBI. No, you didn't do this. No. So the question is, okay, so Dr. Ammons comes in, and the court has already ruled that she is qualified to be an expert based on her curriculum vitae. Says she has never testified before and has never been as an expert before. And now the state is only going to use it in rebuttal, meaning if the defendant gets up there and says, I would never do this, I don't have the propensity to do this, I think he might let it in. If it's limited and it goes to the weight, and let the jury decide which one to give the most weight. If you saw early in this hearing, he ruled against some of these financial crimes coming in, because he claimed under the 403 that they don't pass a 403 analysis. And so he found like some of the financial crimes, covering up for fraud, goes to motive, intent, and the pecuniary value, pecuniary gain for this defendant. He found that that was more character and propensity, meaning you could say, oh, she committed all these crimes, she must have committed a murder. That's not allowed. So the court did a 403 analysis and said that's not coming in this trial, because they haven't convinced the court that that doesn't go to propensity to commit a crime. So a lot of those financial crimes will not come in this trial. So the trial is going to be strictly on the murder, the evidence in the murder, the fentanyl. I think the willingness to get insurance money as a motive is always admissible in court. So this hearing was a little different than you see in a lot of times. This is more procedural, and it's going to whether they're going to let certain evidence in. It can be boring if you don't know it. If you do know it and you're familiar with the terms you use and you understand what's going on here, this is important testimony, because I think that Dr. Fox might come in here and try to use her credentials and her aggressive and dismissive behavior into convincing this jury that this woman couldn't commit this crime or didn't commit this crime. So do you think the judge sees a flippant behavior, her laughing the whole time, and takes into account if she's convicted? Oh, I think absolutely. You saw that with Judge Everett when he sentenced Donna Adelson. She was not remorseful in any way. He told her multiple times in her statement to the court. The judges do not like people who do not show any remorse, especially in heinous crimes where murder's involved. The behavior, I'm sure this judge, he seems like a pretty on-the-ball judge, pretty smart, pretty fair. He's done his research. He understands the rules and the evidentiary issues, fair to both sides. He's going to see her behavior, and I think he'll probably maybe say something to her when the jury's in there. He's not going to let her do this in front of the jury, I can tell you that. He's probably didn't say anything because he's the judge, and it's not going to affect his opinion, but he will definitely have his bailiffs watching, and he's not going to let her make comments, laugh, smirk during the trial. That's for sure. She's not helping herself, but making good decisions is not why she's sitting in that chair. So it's not inconsistent with her to make dumb decisions. And I think she'll continue to make dumb decisions. I think when there's a questionable issue or some testimony comes in that she doesn't like, I think she's going to show facial expressions. It looks like her lawyers don't have any control over her. The young man on the end is slouching in his chair, leaned over with his feet in a very non-professional manner in a courtroom that's being televised. The one lawyer hasn't really said much, the one sitting next to her. Her main lawyer that stood up, she did a fine job. She was prepared, argued her points. Prosecution didn't object at all. And I think that's her style. We'll see. It should be an interesting case. I think, I don't know if she'll testify, but looking at her, the way she acts, she just acts like she doesn't realize where she is and doesn't understand the seriousness of where she is. Maybe she's used her guile and charisma and charm to get where she's at this point, but it usually doesn't work well in the end. Making bad decisions. Yeah, she's that's why she's sitting in that chair. Not because she's smart, not because she makes good decisions, not because she's a family person who was trying to work out her marriage. She's there for a reason. And I think the evidence is going to show that. So, yeah, there's something about the lawyers, Rosie, that I'm taken aback by the young male attorney laughing with her. He should have been telling her, no, don't do that. You always tell your clients, don't make faces, just write notes. Don't show any expressions because the jury's going to watch you. And now you got TV watching. He may be a young lawyer that's sitting there just getting experience and doesn't know, which is okay because everybody has to get their first trial. But he certainly should have cautioned her not to make gestures, knowing that this is on TV, knowing that who knows if someone watching this might end up on the jury, or a friend might be a friend of a juror and say something, you never know. So I think that's right. You never want to be a buddy with your client. They're not your buddy. And I wouldn't recommend you represent your buddy because then you do things you shouldn't do. And you're not objective, you're more subjective because it's your friend. It's going to be an interesting trial. I would guess the judge is going to reserve ruling on this. And I think he's going to say, well, we'll see how the trial plays out. Since you're going to do it on rebuttal, I don't need to make a ruling right now. But I will revisit this issue after the trial when you want to call this witness and make my determination whether or not Dr. Ammons can testify. That's my guess. That would be the fairest way, the easiest way, and the most practical decision to make. Judges don't want to have to make a call if they don't have to, because they don't want to make the wrong call. And his decision may change based on the evidence in the trial, or if she gets on the stand and makes all these crazy statements, or a witness says all this stuff, then the court may feel, hey, wait a minute. If you're going to do all that, I think the state has a chance. The state gets a fair trial also. And I'm going to balance under the 403 that if you brought this in, I think it's only fair, and the jury will weigh the credibility of the witnesses and they make the determination. That's probably what the judge should do. And I think he will, because he seems like a pretty astute judge. And a pretty good judge. He knows the cases, and he was very polite. He wasn't, harsh to anybody. And I'm glad that he's streaming it, because people need to see what goes on in courtrooms. They need to see what defendants do. They need to see what lawyers do. It's interesting, the cases in Utah, but the experts in South Florida. And she has credentials and wanted to go to law school, but she didn't. She ended up getting a PhD and becoming an expert in teaching criminal justice at USF in Tampa. Better curb, yeah. You can tell people to curb their behavior, but they really don't. People act, they are who they are. When you meet people who are they are, you want to look at them in a different way, but they really are, in the end, the people end up doing things you thought they would do, and you're like, oh, I'm surprised. No surprise. Yeah, it's hard when you always have to ask for justice for the victims. It's a sad state of affairs that people believe they can get away with murder, collect money, and their life's going to be so much better. Just think of all the murders we've seen, the cases where they all get convicted. And the evidence is pretty clear, very overwhelming and convincing. And then we had the one trial. So not everybody gets convicted. Not everybody gets charged. Look at Karen Reed. She was acquitted because there was lots of issues. There were a lot of problems with the evidence. The law enforcement was bad. The collection of evidence was bad. All that stuff, you can see a bad case and then you see good cases. You see the Murdaugh case. That was a circumstantial evidence case. Clearly, the state did their job. Charlie Adelson, all the witnesses came forward and a jury made a decision. And juries usually do make the right decision. You know, as a trial lawyer, I can tell you, jurors, you can't fool jurors. You might convince them if they're hesitant. You might find one juror you can hold out. But usually when you have a pretty good case, you're going to win. And when you have a pretty bad case, you're going to lose. And it's knowing when to go to trial, when not to go to trial. But sometimes clients want to go to trial and against your advice. And you do the best you can, make sure the rules. But it's going to be interesting to watch her behavior going throughout this trial. Looks like the happy family there, right? Cute little dog. Glad they blinded out the faces of the boys. He looks like an outdoorsman. I think she was working at Costco or somewhere. He came in, or maybe she was working at Lowe's or Home Depot, I believe. She was a cashier or something. And that's how he met her, which is okay. People meet their spouses all kinds of places. Yeah, Charlie was smirking a lot, and Donna was smirking at the beginning of hers. Karen did. Karen was smirking too. I had a lot of issues with the way that Karen Reed evidence was presented, how it was collected. I thought the experts were not very good. And I think they were not reliable. I know Karen didn't come across as that great as a person. She looked like she had her own issues, but the injuries to him were not consistent with being hit by a car. I can tell you, I've had clients hit victims. I've seen car injuries. None of those were consistent with being hit by a car. None at all. So I had questions from the very beginning. And then knowing that town, Massachusetts, I went up there and saw the trial, and I know that location, that police department, that town, very close-knit, law enforcement, close-knit. Is it beyond the pale that they would cover them? No, absolutely not. It's like insiders versus outsiders. Yeah, Charlie's got his oral argument coming up for his appeal next month. And it should be interesting to see. I think Joel might come up for it. It's at the first DCA, and should be interesting arguments. If anybody in Tallahassee, the courtrooms are open. You can go and watch the oral arguments. You can go and it's in the Taj Mahal. They're on Capitol Circle out down by Southwood. So if you're interested and you're in Tallahassee or you're in Georgia or somewhere you want to see the oral arguments, should be interesting. They're not very long, though. I will tell you, it's going to be about 10, maybe 15 minutes total. They give each side about 5 minutes and then rebuttal. So it's not a lot, but so it was Home Depot she was working. Karen was not hit by a car. No, Karen wasn't hit by a car, but the victim was hit by a car. John. Okay, you're right. Yeah, John was not hit by a car. Sherry Ashton, I kind of follow your line. It sounds to me like he was hit, maybe fell down the stairs, and maybe the dog attacked him. He may have bled, basements, those stairs. He could have died, and they carried him outside, left him there, and then typed in, how long do you freeze? That's certainly an option. And when you have options for a crime, you have reasonable doubt. Do we have any option in this case that he died by fentanyl? How else would he have gotten the fentanyl? Yeah, so we would be thrilled. Tim shows up for the Kouri Richins trial wearing his STA hat like he did that would be funny. In Utah, well, I don't know about that. I would like to do that. That would be fun. Go there and go to the trial. You think they're waiting to change when Judge Wendy? I think that all the charges in against the Adelson family are done. I think they would have charged anybody if they had more. I don't know of any delay, why they would delay if there were more charges. Of course, I don't know, but I don't think time is, I mean, of course, it's a murder case, so there's no statute of limitations. But does it come to some point where Jack says, okay, we're going to go for what we can get and just charge and go forward, or does he just keep waiting? And I know a lot of people thought something was going to happen before Christmas and something before Thanksgiving, but none of that has transpired. I have not heard anything to suggest that any more charges are coming in that matter. So, yeah, I guess. I'm sorry, Kelician. I'm mispronouncing that way. I'm just trying to give an analogy to where some trials, the evidence leads to a conviction, and then sometimes just because you're charged with the murder doesn't mean you're convicted. I'm trying to think of another murder case where somebody was acquitted of the murder. And I'll think of one. But
And based on his experience, he said that in, all his years as being whatever kind of agent he was in drug cases, he always saw this same profile of drug couriers.
I think he said most, didn't he? Isn't that the distinction?
It might have been, I don't know if it was all or most. It was most all.
The key part of the case is that he said most, and that's how Justice Thomas said, well, that's not impermissible under 704B because it acknowledges that there are some outside of most who don't know.
Either way, it's different because he was an experienced witness, not an expert witness. And in this case, Ms. Amon is not an experienced witness. She didn't write this. She hasn't done, she can't get up there and say what the detective said in that case because for a number of reasons. Other people did the studies.
May I cut to the chase a little bit here to see if we see it the same way? I agree with the defense that under cases like United States versus Wells, the expert testimony that Ms. Amon offers cannot be used in the state's case in chief and cannot be used in any part of the case as substantive evidence of defendant's guilt. Here, though, the issue, based on the briefing, is more nuanced. It seems to me that the state could use Ms. Amon's expert testimony in its rebuttal case and only to rebut a general categorical assertion by the defendant in her defense case that this is simply not how it works. This is not credible that someone would engage in a weeks-long campaign to kill someone in the absence of an imminent threat to their life or some kind of emotional or extreme impetus. If there's that kind of categorical generalized argument made by the defense, then I think this testimony from Ms. Amon, which is based upon a retrospective study of killings that actually occurred, saying in the retrospective study of killings that actually occurred, people did plan them over a varying level of time, and there were steps they took along the way. As long as the prosecution did not turn the corner in closing argument to say, well, we showed you elements of plan and preparation on behalf of Ms. Richins. You heard Ms. Amon, so that shows it's more likely than not that Ms. Richins killed her husband. They can't do that in closing. That would be using an inappropriate profile-like argument. But to rebut a categorical, generalized statement from the defense that this is simply not the way homicide works, I think that would be helpful to the trier of fact under 702A. Tell me why not.
Well, first of all,
I think he's absolutely right.
this would be the first time that it's ever used that way. You heard Ms. Amon. This has never been used.
Well, that may be because it'd be the first time that a defense has ever made that kind of argument, but I'm not sure we're going to have to cross that bridge here.
Well, we may not. But I think it's never been used because it's not reliable. The study wasn't made even though to pick out individuals who commit violence. It was developed, she said, the only time.
They're not using it predictive in my hypothetical. They're only using it to rebut a generalized statement of murders don't get planned like this.
Well, it can't be used predictive. I think that was pretty clear.
Right.
It's
I'm agreeing
not.
with you on that. We're past that.
All right. So my point is that when she talked about individuals, though, she talked about how the study applied to assassinations. The study was not developed in any way, shape, or form to look at this sort of instance.
Let's be careful here. I think there's a side of the V that would call this an assassination of a non-political figure, but nonetheless, stay focused with me. Why wouldn't that be helpful to the trier of fact under 702A to understand sometimes killings are targeted? We know because we've studied killings that have actually occurred. Sometimes they're planned. Sometimes they take time for that plan to develop.
She has no
I
answer.
don't understand how that's helpful. Yes, isn't that general knowledge that sometimes killings are planned? I don't understand.
Know if it is or not, but it's that would be like if the defense is going to make the argument, these things are never planned. This is simply not the way it works. Now, I don't know if you're going to make that argument, but you're asking me to exclude Ms. Amen under any circumstance, and I'm not sure you've carried that water.
Well, we're asking that she be excluded because it's under I'm going to move also under 403 and 404B. It's highly prejudicial for someone to get up there and tell a jury, I'm an expert, and it's if we were to make that argument, which I don't know. Let's see, we were to make the argument. She's a mother. She wouldn't have killed the father of her children. How prejudicial is it for someone to get up who claims they're an expert, who's not an expert, never has testified, never has used the study in this way, and then tell a jury why we're wrong?
Yeah, but you changed my hypothetical. Ms. Amen doesn't comment in any way on the specifics of one mother killing her husband or the father of her children. I'm not suggesting you can't make the argument that Kouri Richins had so much to lose by doing this, it reduces the likelihood that she did it.
But that opens the door for Ms. Amen to come in under your hypothetical
No,
to
it
say,
does not.
no, that could happen.
Please stay focused.
Okay.
A general, absolute, categorical statement by defendant. Murder doesn't happen this way. They're always emotional. They're always in response to a threat. They're always as part of a fight or as part of a criminal enterprise. I don't know what you'd say, but if you want me to exclude her entirely, I'd have to say that there is no set of circumstances in this case under which her testimony would be helpful to the trier of fact, and you haven't carried that burden.
So you're saying that, in your view, the only way her testimony could be relevant is if the defense says this kind of murder would only happen in a enraged emotional state.
Yeah, or in response to a threat.
Or in response to a threat. That's the only way this is coming in.
Right. That seems to be correct. Tell me why that isn't correct.
Well, I don't know that we really even have a problem if that's the court's ruling, that it's only coming in under one specific circumstance. I just think about our general objection, though, is it's just not reliable under 702 under any circumstance. It doesn't matter what the circumstance is. I think that
this is why I'm not persuaded by that. The defense keeps, at least implicitly, taking the position that if two people could apply this framework and reach different conclusions, it's not scientific, it's not reliable. Is that one of the defense arguments?
well, one of many.
Sure.
It's not.
Now, that would mean that every physician that testifies in a medical malpractice case is unreliable, because in every single medical malpractice case, there are competing expert testimonies regarding the standard of care and whether it was breached.
Well,
and they're both admissible, and it all goes to weight, not admissibility.
That's right.
I thought about
Absolutely.
that as I was listening to her testimony. And I think the difference is, and I don't do medical malpractice, but I think the difference is when we have competing medical experts, it's typically based on actual scientific research and knowledge. And
Or
they
their
might have
education,
different,
training and experience. They're not citing studies most of the time.
but it's based in science. You can get two experts who have a different opinion when they apply the science, but this isn't, any applied science of any kind. This is just a completely subjective theory.
But the law enforcement expert in Diaz wasn't applying science either, but he was offering specialized education, training, and experience. That's the subject of Rule 702.
Well, he was not an expert, that's true, but he was
In
applying.
Utah, he would have to be qualified as one in order to say what he said.
I know we see that in federal court all the time. They're
It's not
applying
federal
their own experience. I am a DEA agent. I have arrested 1,000 drug couriers. Of those 1,000, the vast majority fit these characteristics. That's very different than what Ms. Amon wants to testify to. It's very different.
I think the rigor of Ms. Amon's testimony is greater in terms of, here are the studies. We looked at killings that actually occurred, identified these factors. We've published it. We've added it to the model. This is how we use it, full stop.
But none of those studies, well, first of all, she really didn't tell us what any of those studies were, but
This goes to weight, and Dr. Fox will be able to tell the jury why this isn't going to help you make these decisions.
that's correct. But if none of the studies have to do with the domestic violence case, how is that helpful to the trier of fact?
Because if you're going to make a categorical people don't murder people this way statement, it has nothing to do with domestic violence anyways.
And I think one of the other problems is when she stated you can go all the way down the pathway of violence and then they don't commit a murder. So how is that even helpful?
That increases the reliability of her testimony instead of decreasing it, because it
Right.
acknowledges that there are people on the pathway that fall off. So it's a most, not all, a la Diaz.
That's right. Good judge. Very good.
Okay.
Smart judge. She's losing, and she.
You're going to want the last word because I think
All right,
it's going
I'm
to
good,
vote
yes.
with my ruling here. Ms. Shervanek.
Your Honor, I don't know that I have much to add. I think that the type of testimony that Ms. Amon would offer fits squarely within 702. She has specialized knowledge that would assist the trier of fact in making a fact of consequence more or less likely, and that they, being the jury, could use the analytical framework of the pathway to violence, taking the facts that they've heard presented or theories that they've heard presented through witnesses and applying them to a framework that Ms. Amon lays out to understand how a person in a position commits a murder under certain circumstances. That testimony assists the jury in understanding how this case could play out, how it explains a theory or rebuts a theory put forth by the defendant about how this murder was committed and why it was committed. And the jury can use the framework that she presents or wholly discount it if they find it doesn't apply. And that would be up to the jury to decide. But given the type of testimony that Ms. Amon proffered and that we expect her to present as a rebuttal witness, it fits solely within 702. And for those reasons, it's admissible.
Okay. I understand the state's position. Ms. Lewis, anything further?
I guess my last word is just that under 702, I don't see any scenario under which this is a reliable science that could be presented to the jury. And I also don't think the testimony was that the pathway to violence is a most. It's an occasional. It's a few. So I don't think that they're to admit this is reliable under Rule 702 in any matter, I think is inappropriate.
Okay. All right. All right. The issue before the court is whether Ms. Amon's proffered expert testimony should be excluded in its entirety. The motion is made under Rule 702 and 403 of the Utah Rules of Evidence. The court addresses Rule 702B first. It provides that scientific, technical, or other specialized knowledge may serve as the basis for expert testimony only if there is a threshold showing that the principles or methods that are underlying in the testimony are reliable, are based upon sufficient facts or data, and have been reliably applied to the facts. Here, first, it bears noting that Ms. Amon is being offered as a blind expert. She is speaking about general principles, not applying a framework or analysis to the specific facts of this case. Moreover, her testimony is based upon a retrospective study of killings that actually occurred. And based upon that retrospective study, her testimony identifies some commonalities that exist among completed killings, while also acknowledging that people that begin on the so-called pathway to violence often fall off at any of the stages, sometimes begin again and then fall off again. That just because they begin on the pathway does not predict or mean that they will complete a killing. Under Rule 702A, the court finds that based upon her education, training, and experience, as shown in her CV, Ms. Amen is qualified as an expert in this field. And her testimony based upon that retrospective study is sufficiently reliable and based upon a sufficient set of facts or data, given her description of those retrospective studies and their updates over time, to satisfy the minimal threshold for reliability under Rule 702B for a blind expert. The real issue is whether her testimony would be helpful to the trier of fact under Rule 702A, and under what circumstances. To be clear, under cases like United States versus Wells, 879 F. 3rd 900, which is from the Ninth Circuit in 2018, Ms. Amen's testimony cannot be used by the state in its case in chief as substantive evidence of guilt. And even if she's called as a rebuttal expert, the state cannot refer to her expert testimony as a basis for the jury to draw comparisons that would weigh in favor of a substantive finding of guilt. However, in the event that the defense makes an assertion in its defense case that is categorical and general, for example, something to the effect of that it's simply not credible that a person would engage in a weeks-long campaign to kill another person in the absence of an imminent threat to their safety, then Ms. Amen's testimony regarding the retrospective study of completed killings showing a feature such as a preparation and plan over time would be helpful to the trier of fact under Rule 702A to rebut that generalized categorical assertion by the defense. If the defense makes an assertion to the effect of Kouri Richins did not commit these crimes, and one of the reasons you can be sure of that is because Kouri Richins had so much to lose in her personal life and her family life if she had, that is a case-specific level that Ms. Amen's testimony would not be helpful in rebutting. However, if the defense makes a absolute or generalized categorical statement regarding how homicide unfolds or whether it ever unfolds as alleged in this case, Ms. Amen's testimony would be helpful to the trial of fact in rebuttal. And it would not be unfairly prejudicial in a way that substantially outweighs its probative value, because it would not be able to be used by the state as substantive evidence of guilt. Rather, it would only be used to rebut the defendant's categorical assertion regarding features related to homicide. The court acknowledges that pursuant to this ruling, the likelihood that the defendant is going to make such a categorical high-level argument is pretty low, which means that the likelihood that Ms. Amen will ever be called to testify is also pretty low. But the fact remains that there is not a basis to grant defendant's motion in full, because there is a cognizable basis upon which her blind expert testimony would be helpful to the trier of fact under Rule 702A, and which its probative value would not be substantially outweighed by the danger of unfair prejudice under Rule 403. So the defendant's motion to exclude Ms. Ammon's testimony is granted in part and denied in part. She cannot testify in the state's case. The state cannot use her testimony, even if it comes in rebuttal, as substantive evidence of guilt, either directly or by inference. And her testimony would not be helpful to the trier of fact to rebut case-specific assertions of why Kouri Richins did or did not commit the act she's accused of. However, if the defendant makes a categorical assertion regarding how homicides unfold, the court will revisit this issue to determine whether Ms. Ammon's testimony should be allowed in rebuttal. Let me pause there for a moment. Ms. Shervanek, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Lewis.
No, Your Honor.
Okay. Ms. Lewis, where would you like to go next?
What do you do, Throckmorton?
I guess Mr. Throckmorton would be
Okay.
next. So Ms. Nestor will be. Do you want to move or are you okay there?
Ms. Nestor, I have looked at Mr. Throckmorton's report from June of 2023 and his amendment in March of 2025. I'm really familiar with him from other cases in terms of his background and his method. Tell me what you see as the problem in this case.
So, Your Honor, can I come to the,
Wherever you're
I
comfortable,
hate bending
please.
over to
Yeah.
reach that microphone. May it please the court, good morning. Your Honor, as far as Mr. Throckmorton's testimony, the objections that we have to his testimony, it's basically focused on the first prong of 702, which is whether or not his testimony can be of any assistance to the finder of fact. And the main concern is his conclusions or lack thereof are basically, I looked at this. I cannot say at all whether Kouri Richins signed Eric Richins' name or didn't. I can't
Right.
say she did. I can't say she didn't.
Right. You skipped a step though.
Right. Well, I'm getting.
Okay. I mean, he does say with a much higher level of
Right.
probability
Right.
that Eric Richins didn't sign it.
Right.
He just
So-
can't say that it was with the same level of probability or any, depending on the document,
Right.
that it was Kouri Richins that made the simulated forgeries.
Right. And the concern that we have is his materials that he provided and that we expect would be laid forward before the jury. Take little pictures of letters and compare them. And, you know, all of us are human and we all have eyeballs, and or those of us blessed with the sight have eyeballs that work. And we are tempted to look at those things and compare them and contrast them. And it goes back into a jury room. And the bottom line is they're calling the expert to say, I cannot draw a conclusion that Kouri Richins signed these, signed his name, signed the initials. Even his finding that Eric, I believe the finding he had was a strong probability
For one of them.
that Eric Richins did not initial the documents, not that he didn't sign the power of attorney, but that he didn't even, a strong probability he may not have initialed them, which is not even to the standard of, you know, beyond a reasonable doubt. It's not anything close to that. And the concern that I have is you're taking an expert who is going to basically say, here's all this stuff. I'm going to send this back in the jury room. Y'all can sit there and look at these initials. You can try to figure it out yourself if you think that he did it. But I'm, as an expert, saying I can't say Kouri Richins did.
Maybe pause there for a minute.
Yeah.
So my understanding of Utah law is that lay jurors can, in fact, compare signatures in the absence of expert testimony. That is something they're allowed to do.
They can, but the problem is you're trying to layer on top of that this expert who is giving an opinion that's a non-opinion to support a finding that the state wants, right?
Okay. Well, maybe.
And it's not supported by the science. The second prong that we're attacking.
Pause with me for a minute, though.
Yeah.
I apologize.
No, it's fine.
So the concept of the state showing documents and arguing to the jury, take a look at these. You can see with your own eyes that doesn't look like Eric Richins' signature. That is permissible argument, and that is a permissible way to admit that evidence, correct?
I think they could try that. I mean, they could do that.
Right. Okay.
Right.
Then we look at, all right, does Mr. Throckmorton's analysis assist the finder of fact in determining whether the state has carried its burden of showing beyond a reasonable doubt that defendant forged some documents, right? And a step along that way from the state's perspective is, well, first we need to show that Eric didn't sign them.
Right.
So focus on that part for me for a moment. Why isn't Mr. Throckmorton's testimony admissible on that part?
Well, one big reason is that the initialing, there is no statement at all that Mr. Richins, so there's two documents at play. There's a power of attorney, which according to Mr. Burmester from the county, they're not even going to get into that unless we introduce the power of attorney as an exhibit. They're not even planning on doing it in their case in chief, which I just found out this morning.
Okay.
But let's say hypothetically, for some reason, we need the power of attorney. They're not even saying he didn't sign it. Like, their expert is not saying that's not his signature. They're only questioning whether he initialed each and every little blank on the side, right? Of which the expert cannot say. He cannot say he didn't. He cannot say to any degree of certainty whether Kouri did. He said absolutely no conclusion as to whether Kouri did, but he also can't say for sure that Eric didn't.
Well, doesn't he say that there is a strong probability that Eric Richins did not author the ER initials on the power of attorney that defendant allegedly used to obtain a HELOC?
Yes.
Okay. He's used a strong probability for that opinion, right?
Right, but that also provides for the possibility that Eric did initial it, right? I mean,
certainly,
yeah.
And the jury can weigh his testimony.
Right.
In terms of admissibility, it would seem to be helpful to the trier of fact to receive an opinion from a qualified expert as to whether Eric Richins initialed a document or not, right? Because if he didn't, it leaves open the possibility that somebody else did. And then when we go to, well, does he have an opinion as to whether Kouri Richins was the one that initialed it? Right. I acknowledge that his level of certainty there is much lower, if not, there's no conclusive proof one way or the other.
Right.
But why wouldn't you want to let that in?
Right. Well,
if the state wants to call him to say it, it certainly doesn't hurt defendant.
Yeah, if he testifies at all, trust me, we do want that to come in.
Yeah.
The concern that I just have is just misleading this jury about these floating standards, because under the National Institutes of Science report, under the PCAST reports, the reliability of subjective handwriting analysis has been brought into serious question by the general scientific community. I provided those materials in my brief. And to have a layer of persuasion going to the jury of an expert that is relying on a science that has not been generally accepted by the national scientific community. And I specifically identified where in the NIST report, and where in the PCAST report, the scientific community says, look, this is just a subjective. It's no better than if me and you and the deputy all sat down and just guessed if it looked like it matched.
Doesn't Mr. Throckmorton reference studies saying that certified handwriting analysts are better than the lay public at identifying differences in simulated forgeries?
He does, and we would obviously attack that if he took a stand vigorously. But yes, he does. He states that in his report, which may be enough to get you past the gatekeeping requirement. That's up to the court. I do also have some real concerns about whether portions of this needs to be redacted. One of the conclusions he was asked to, or he wasn't even asked, he did it sua sponte, I think only applies if it's a court, but he did it on his own when he was submitted the documents in question. One of the documents he was submitted on the amended report as recently as a few months ago. Now we're 3 years after the death, and he's just now being submitted new evidence, right, to evaluate. But that's what happened. And they gave him a report by the like a notary page where the notary had signed. And he just on his own makes a conclusion that a date has been altered, a number, not a letter, not handwriting. There's no evidence whatsoever that either that was asked of him to do, that he's qualified to do that there's any science backing that up.
I don't know that the state's offering that opinion at trial. Am I right about that, Mr. Burmester?
I don't even know what she's talking about.
Okay, so it sounds like a no.
Okay, well then if that report comes in, we're going to ask to redact that section of
Reports
it.
don't come in, they're hearsay.
Okay.
His demonstratives may come in.
Okay.
He usually he does in fact have demonstratives, and those will need to be disclosed to the defense, but the report's hearsay.
Right. And also whether or not, that'll go to wait. We'll deal with that when he takes the stand. So I think really that it's really a two-based argument that we've presented to the court. Two bases for our argument. One is that we don't believe it's helpful because there is no conclusion. Number two, we question the science of handwriting analysis. I provided the court with the scientific community's concern about the reliability of handwriting analysis, that it's really slowly but surely being relegated to junk science. And on that ground, we think, and what it adds is minuscule. It provides no guidance to the jury. So as far as we're concerned, if you're going to exercise a gatekeeping function at this point, this would be the point to do it. And we would ask that he be prohibited from testifying as an expert in this case.
Okay, you'll get the last word.
Yep.
Mr. Burmester.
To clarify, the state would offer Q1, Q2, Q4 in the event arguments come out in the defense case in chief. I don't know, we come up with 100 hypotheticals, but maybe something, she's a great businesswoman and somehow puts into question evidence that we might offer, which could include that power of attorney.
And Q1 and Q2 are definitely the power of attorney. Is Q4 also?
Q4 is when Mr. Throckmorton is asked, all right, we have some knowns from Ms. Richins.
Right.
Now do the same thing you did.
Okay.
So with regard to those would only, that is how I would see us calling Mr. Throckmorton in rebuttal. Main point is there's not an agreement that they have to introduce the power of attorney before we would introduce it. It would be a whole set of facts that might make that come about.
Is the power of attorney, forgive me, I didn't go back and look, is the power of attorney the basis of one of the forgery charges?
It is not.
Okay. So why would the power of attorney be discussed in your case in chief at all?
Oh, I'm not offering the case in chief.
Okay,
That's
got it.
precisely why.
I see.
have to be some facts that arise in the defense case.
Got it.
That would implicate offering that exhibit, and therefore its authenticity would be at issue.
Understood.
Okay, so that leaves us with just the true stage application signature, which is indeed at issue, identity of the forger and identity of that insurance fraud count.
So there, I understand the state's argument to be Mr. Throckmorton helps the trier of fact determine whether we've carried our burden on the forgery count related to that insurance application, because he says, he opines that it was probably not authored by Eric Richins, and it appears to be a simulated forgery. Full
Correct.
stop.
Yes.
Okay. And that, in the state's view, is circumstantial evidence that makes it more likely that it was forged by Ms. Richins,
Yes.
given other factors related to motive, access, et cetera.
Yes.
Okay.
I get this. I was in the courtroom in Gersh v. Gersh, and so I know the court is familiar with Mr. Throckmorton, and we've proffered all those in our pleadings, all his qualifications. So I don't intend to talk about that. However, there is a notion, and Mr. Throckmorton is here, President Court, we can call him as a witness. He would talk about how handwriting comparison has been used in courts for 200 years. And since the 70s, there's been an intense professionalization of that theory. And that history goes to prong C for demonstrating its threshold. I would also just like to address two other things, and that is the pathway forward, 2009, where the scientific community who's addressing all, what is the status of every single forensic science? And there's a portion about handwriting, and the committee agrees that there may be some value in handwriting analysis. The scientists who composed this document, of course, hold DNA at that time as being the gold standard. Obviously stated there were some things that need to be addressed, but certainly doesn't say it ought not be admitted. PCAST doesn't even directly address handwriting. It says all these other sciences like handwriting, these same things should be applied to them. But none of them say scientific community is rallying around some notion that it's junk science.
Certainly not in the state of Utah. I've looked. I cannot identify any time that Mr. Throckmorton has been excluded in the state of Utah. I can only find cases in which he's been admitted as an expert.
Unless the court has further questions.
I understand the state's position. Ms. Nestor.
Nothing else, Your Honor.
Okay. Before the court is the defendant's motion to exclude the expert testimony of Matt Throckmorton. Mr. Throckmorton is offered to testify that the Eric Richins signature on the True Stage insurance application that is the subject of the charged forgery was probably not authored by Eric Richins and appears to be a simulated forgery written by someone who is familiar with or has access to Eric Richins' known signature. In addition, Mr. Throckmorton has been noticed as someone who may offer testimony in rebuttal or impeachment that there is a strong probability that Eric Richins did not author the ER initials on a power of attorney that the defendant allegedly used to obtain a HELOC on the Richins' home, and that there are mere indications that the defendant wrote those initials. The court determines under Rule 702A that testimony, which would come in the state's case in chief and perhaps in rebuttal, respectively, is helpful to the trier of fact because it would assist the trier of fact in determining whether the state had met its burden to show that Ms. Richins committed the charged forgery count regarding the True Stage insurance application and may be relevant to show Ms. Richins' conduct related to the HELOC in rebuttal. Moreover, based upon the court's review of Mr. Throckmorton's CV, his education training experience, and his substantial history and experience in testifying, certainly in state courts in the state of Utah, the court finds that he is qualified as an expert in the field of handwriting analysis. Regarding defendant's objection to the reliability of Mr. Throckmorton's analysis, the court finds that his analysis and his methodology, and therefore his testimony, are sufficiently reliable under both rules 702 subsections B and C. Under C, the court finds that Mr. Throckmorton's analysis, because it is performed consistent with and measured against the SWIG doc standards, is generally accepted by the relevant handwriting analysis community. Moreover, even putting that aside, the court determines that his methods are reliable in as much as he is able to describe the way he compares the questioned documents to known samples of both Mr. Richins, the decedent, and also Ms. Richins, the defendant. He applies that reliable methodology to a sufficient set of known signatures, and he does so in a way that does not ignore any uncontroverted features of those signatures or other uncontroverted facts. That is, he applies his methodology to a sufficient set of facts or data in a reliable manner. Therefore, his testimony is admissible under Rule 702B. Finally, the court is not persuaded that his testimony, the probative value of which has been described, is substantially outweighed by the danger of unfair prejudice or other concerns under Rule 403. For these reasons, the defendant's motion to exclude Mr. Throckmorton in his entirety as an expert witness is respectfully denied. Mr. Burmester, do you need any clarification of the court's ruling?
No, Your Honor.
Ms. Nestor?
No, Your Honor.
Okay.
I am here.
Next.
Big thanks to Tim Jansen as the preliminary hearing continues.
Hey, Joel.
Next week, Ms. Nestor
Hey, Tim.
is
Any
also
big developments?
handling that.
Not
Very
really.
good.
Okay.
You ready to turn to Dr. Benino, Ms. Nestor?
Got a way to sell it, Tim.
Ms. Shervanek?
Couple experts.
May I ask you a couple of
And,
questions?
Yes.
he kept out some evidence, not surprising, but
Okay.
the defendant is smiling and laughing, showing
Yeah.
very
Ms.
poor.
Shervanek, is there any
poor taste.
admissible evidence of domestic violence by defendant against Eric Richins prior to the allegations related to February 14 of 2022?
I don't believe that would be presented in the state's case in chief.
Okay. Is there any admissible evidence that Eric Richins had any subjective knowledge that defendant attempted to poison him on February 14, 2022?
That he had knowledge of it?
Right.
Yes.
Tell me what admissible evidence there is of that. We went through this for a couple of hours with Mr. Wright.
We did.
I spent some time on this yesterday. I don't know that there's any other admissible evidence that would show that Mr. Richins knew that anybody had attempted to hurt him.
May I have a moment?
Of course.
Not a good sign when she has to look to her bosses or the investigator to answer the judge's question.
Yeah, Tim, so I'm just joining. We just had the Nick Reiner hearing. The headline out of there is Alan Jackson has stepped down as his attorney, and his arraignment has been continued. But what's the headline here, Timbo?
Well, they're trying to keep some experts out. The defense is trying to keep an expert out about pathways to violence. They're concerned. The state thinks she's going to come in and say murders don't happen this way. And they brought in an expert from USF, pretty reliable expert, got a lot of background, but and the judge ruled may come in and rebuttal. There was some information about a forged ID for the power of attorney, a forged true stage application for the loan, the HELOC loan, which I think is going to be they got an expert, the state does, saying it wasn't Eric Richins' initials or his signature for that HELOC. That's going to come in. Then he limited whether he could say he thinks that Kouri did it. He can't testify that, but he can say that for sure it wasn't Eric's signature.
I think the court is aware of what the admissible evidence is, the testimony from Josh Case and Cody Wright, that
Cody Wright's not going to testify, as I understand, at trial, pursuant to, not at least regarding the events of February 14, 2022. I don't think he has any admissible testimony regarding that day.
He does. His admissible testimony are his observations, not the content of Eric Richins' conversation, but his observations about Eric Richins' demeanor,
You didn't see him.
voice
It was
sounded.
it was all on the phone.
Right, but his hearing observations about his voice, how he seemingly sounded on the phone during those conversations, and not the content that aren't admissible because of hearsay rules. But there are observations that he could make through that phone call that is admissible.
Proffer that for me.
But this is exactly what Mr. Wright testified to previously.
I don't know that he can give that testimony regarding his observation of the manner in which he was talking without saying what he was saying.
I disagree.
Ooh.
You're proffering that Mr. Wright would say he sounded scared.
That he sounded somber, that he sounded concerned. I don't remember the exact words that he used when he testified, so I don't want to misstate those. But certainly he testified that during that phone call, Mr. Richins had a certain demeanor that struck him and that he remembered. And then he testified to what that demeanor was.
Okay. All right. Let's assume that comes in. Anything else?
There are also text messages between the defendant and Eric Richins about the sandwich that was left. And
So let's be specific. There's
Sure.
a text message from June between defendant and her friend indicating that she left a sandwich. And then there's a text message from Eric to Kouri at 11:33 a.m. on February 14 saying he's not feeling well. I'm going to go lay down. If I don't feel well, I'll go to the hospital. Anything else?
later in the day. Sorry, I don't have all of those messages at the forefront of my mind.
That's okay.
Your Honor, late in the day, late afternoon on February the 14th, there are text messages between the defendant and Eric Richins, which don't directly, he doesn't directly say something like, you just tried to poison me.
No.
But the state will argue that his messages and her non-responses for several hours, and then their ultimate exchange about he says something like, I got dinner for you and left it on the seat of your car or on the seat of my car. The state will argue that those indicate he was well aware of what happened on February the 14th at about 11 a.m.
Okay. All right. Okay. My concern is that in the absence of admissible evidence, in the absence of the jury hearing the content of Mr. Richins' statements to Kouri Wright, there isn't a basis for the jury to conclude that Mr. Richins was acting inconsistently by staying with Ms. Richins or not doing something more acute between February 14 and the day he ultimately died. And without a reasonable basis to find that he acted inconsistently, I'm not sure why Dr. Venino's testimony is helpful to the trier of fact. And I'm more concerned that under 403, it would invite the jury to speculate about whether there was, in fact, a prior history or prior experiences of domestic violence that aren't in the record.
I think there are other instances, other facts that would be presented at our case in chief that are maybe not on their face what people typically consider domestic violence, meaning physical abuse. And that's the crux of it. For example, if there is infidelity, why do you stay in a relationship? For example, if someone is...
Does Dr. Venino have anything to say about that?
What's that?
Does Dr. Venino have anything to say about that?
I think these go to the counterintuitive behaviors. These go to manipulation and control that exist outside of physical abuse in these types of relationships, which is exactly what needs to be explained, because the jurors may have questions of why wouldn't you leave if you knew you were being cheated on? Why wouldn't you leave if you thought this person was taking your money?
Well, hold on. The lay jurors are perfectly capable of figuring the first one out in their everyday experience. The second one as well. The state, I think, has a more thought-provoking point of, if you knew somebody tried to kill you, why'd you stay with them? Now that, I understand, would require or may allow the admission of specialized knowledge regarding domestic violence relationships and cases. I got that. That's, I think, a valid argument. I'm just not sure there's any foundation for the jury to conclude that this relationship involved domestic violence before Mr. Richins ultimately died.
I think that the court is considering this as domestic violence in the context of a typical physical abuse case that we're not alleging.
I'm not suggesting otherwise. I'm more concerned with Dr. Venino talking about it that way.
And she would not.
Then what does she do that's helpful?
It's in her proffer. She can certainly testify to it, but it is the counterintuitive behaviors, it's power and control and manipulation outside of physical abuse that does not include physical abuse.
Okay. All right. Mr. Bloodworth, did you want to add anything?
Yes, Your Honor, thank you. As it relates to what I would most likely expect the testimony to involve Valentine's Day, why not? Why if you thought she just murdered you, do you still stay?
Right.
And it seems to me that where the court might be hung up is in the probative value of the evidence showing that he knew versus
Or lack thereof,
or lack
of evidence showing that he knew.
the
Yeah.
probative evidence showing that he knew versus the prejudice that would come along with perhaps an improper inference.
An improper inference of something prior to February 14th.
Prior to February 14th,
Right.
correct, Your Honor. So I don't know that at this point in time, the court has the full amount of evidence that Eric knew, despite kind of some proffers just now. This may be a decision that the court wants to reserve on under the scope, kind of make the reservation of the court needs to hear the evidence that Eric knew. Upon hearing the evidence that Eric knew, the court can make a 403 decision. I think the court can make probably the 702 decision part of that today, but I think the court needs more information on the probative value of the evidence that Eric knew.
Okay. Pause there for a minute.
Yes, sir.
Ms. Nesser.
Your Honor, Ms. Dr. Venino, I think she's a doctor. She has certainly not been identified as a family relations expert, a good or bad marriage expert, a marriage counselor.
I know, but respond to what Mr. Bloodworth just said.
That's what I'm trying to get to. So if they're trying to argue that there's been infidelity or there's been arguments in their marriage, infidelity on both sides of their marriage, which is an answer to a question about why you wouldn't leave. But that goes way beyond what the narrow area that she's qualified in. She's qualified in domestic violence. If you look at her CV, 99% of it deals with sexual assault victims. A tiny percent of it deals with domestic violence in the home that is not connected to sexual assault. Almost all of it's connected to sexual assault. So her specialty, while they may want to put that case on that, that she was a bad wife or whatever they want to try to argue, this expert is being called to opine about violence in the home, not just being a bad wife or being controlling or manipulative of your spouse, but of a spouse being in fear due to emotional or physical coercion to the point of being in fear. And there's zero evidence that I've seen in 10 terabytes. What are we up to? 12 terabytes? 12 terabytes of discovery. And if they've got some evidence out there that there was domestic violence in this relationship and I don't have it yet, I submit it's not coming in. So the prejudice would be outrageous to allow this witness to get on the stand and opine expertly that because there were problems in the marriage, that this was a situation that put Eric Richins in fear of domestic violence.
That's not what Mr. Bloodworth was arguing. He was arguing that I should wait to see how the evidence comes in the state's case in chief to determine whether they've laid a foundation for the jury to draw a reasonable inference that Eric Richins did in fact conclude subjectively that Kouri Richins tried to kill him on February 14th and then stayed with her. If they do, I think their argument that Dr. Venino's testimony is helpful to the trier of fact is stronger. And we can have a conversation about it today or tomorrow or in the future. If they don't lay the foundation, I don't think it can come in because it won't be helpful to the trier of fact. And even if it had some minimal helpfulness, it's the danger of inviting the jury to speculate about whether there was some other history prior to February 14 regarding domestic violence, whether they've misheard the evidence and are confused or misled. That's too high under 403. But Mr. Bloodworth's point on behalf of the state is, rather than doing this by proffer, why don't you just hear it come in and then decide if we can call Dr. Venino after we've tried to lay the foundation for what we think we're going to be able to show.
Well, one of the problems is, if she's going to come in, there's things we as lawyers need to do to prepare for that. One thing, we may want to get a rebuttal witness. We honestly did not believe that her testimony would ever come in at this trial because there's zero evidence of domestic violence on Kouri's part, right? So there are things we need to do to prepare that preparing at the last minute puts us at a significant disadvantage. I think you're always entitled to revisit any ruling you ever make, right? You're the judge. You can revisit a ruling at any point in a trial if the evidence changes or something changes.
Certainly.
But as this evidence stands right now, they have not propounded evidence sufficient to get her testimony in at this point. If they do that later, then they can ask you to reconsider. But right now, I think the only proper ruling would be to rule that there's no standing right now to let her testify. If that changes, you can reconsider it. But right now, they've not propounded that evidence. I've never seen that evidence. And we're, a month out from trial. I seriously doubt we're ever going to see it. But that's what we would ask you to do at this point.
you acknowledge there's a little bit of internal inconsistency to what you just said. I mean, I agree with the last part that I can say, well, she can't testify until you lay foundation.
Right.
But once I say they've laid foundation, you're going to be right on the horns of the same dilemma you just described in terms of needing to have a rebuttal expert prepared to go.
Right.
Okay.
Well, I mean, if it depends on your ruling, how we approach that, right? I mean,
Talk to me about, assume that there was foundation in the record today, that there was admissible evidence that Eric Richins had a subjective belief, well-founded or otherwise, that Ms. Richins attempted to poison him on February 14, 2022, and elected not to do anything about it. It would seem that that would satisfy the 702A standard for helpfulness for the jury in terms of explaining why people who suffer violence in a domestic relationship don't immediately get out of it.
that still doesn't mean that there's any evidence of that violence in the relationship. Even
You
if
got to
that,
accept my hypothetical
right.
that he subjectively believed that she did and didn't get out. That would seem to open the door to Dr. Venino's testimony as helpful to the trier of fact. Do you disagree?
I would disagree with that.
Tell me
obviously. Well, based on her area of expertise, as I read her proffer, her theory is, it's almost like we use the word grooming in child sexual assault material cases, but that idea of being in such a violent and traumatic relationship that basically a person just gives up. It's kind of the
Well,
burning
that's
bed.
not what she says. I mean, quote, there are many reasons that a victim of intimate partner abuse doesn't simply leave an abusive relationship, including love/hope for change, economic constraints, lack of perceived acceptable alternatives, social isolation, and fear.
Right. There's no evidence of any of that. In the
No,
very
but in my hypothetical, there would be evidence that he believed that was the case.
okay. Accepting that hypothetical, that evidence that does not exist now somehow appears at trial for the first time ever.
Right.
And is allowed in, even though we object like crazy because they didn't give it to us before. The argument would be that her testimony, my understanding is she's a blind expert, right?
Right.
So she's not going to be able to take that evidence and analyze it anyway. So how does it change her position at all from right now?
Well, because right now, in the absence of the foundation that you assert is missing, that I have concerns is missing, that Mr. Bloodworth is saying, hold the phone, let us lay it at trial. I agree that her testimony would be unhelpful because it's not relevant to
Right.
the facts of the case.
Right.
If they lay the foundation, it suddenly becomes relevant to the facts of the case.
I don't know. I think it gets very, very painfully close to opining on the mental state. I mean, it's the same argument that you raised before when you were talking about the testimony of the profiler, right? Like, how close are you going to walk to that line that you're giving an expert opinion about what's inside someone's brain and then extrapolating that, one step over to defense counsel table, right? And I mean, basically her testimony would be under circumstances where someone believes that their life is in danger, it's perfectly rational for them to stay. So it must show that they did believe it, but that they just didn't act on it. I mean, she's opining on what would be in Eric
It would
Richins.
mean they'd offer her testimony for the inverse.
Right.
The fact that he didn't leave is not necessarily an indication that an attempt in his life didn't happen on February 14th.
I mean, I had a case very similar to this one time. I had a rape case where the victim of the alleged rape testified wholly inconsistently, like 6 different times about what happened to her,
Right.
to the extent of like where it happened, how often it happened, in what position it happened. Everything was just absolutely in every statement she gave. And the federal government called a witness to testify, an expert to testify that rape victims are more likely to be confused. So the fact that her statements are consistent with trauma and make it more likely that she was a rape victim, right? And we have this huge battle over that about how far can you use an expert to explain away your inconsistent evidence, right? Evidence that's inconsistent with guilt. And it shouldn't be that you should be able to call an expert witness and say, hey, we're presenting something that's wholly illogical and irrational, but we're going to call this expert up here and say, well, this certainly would be a perfectly honest reason why Mr. Richins would believe that, it was a healthy thing to stay with someone who just tried to murder him, right? And so it eliminates their problem with their evidence, and it goes into his state of mind, which an expert shouldn't be called to testify about.
Well, we could talk about that under Diaz.
Right.
But, okay, I understand your position. Ms. Shervanek, Mr. Bloodworth, anything else today?
No, sir.
Okay. Let me take it. Oh, I'm sorry.
Sorry, Your Honor.
That's okay. Anything else on the record at the moment?
No, sir.
Let me take a 10-minute break. Okay, thank you.
10-minute break. Love this judge. Richard Mazarek, could listen to him as I'm going to sleep instead of Moshi, which is what I'm sometimes tortured with my 6-year-old. But now I figured out I don't have to pay for Moshi when I can just go to Spotify and listen to lullabies. Tim Jansen, I'm a little loopy because we just covered the Nick Reiner, what was supposed to be his arraignment, which has now been continued. But again, the first thing that caught me off guard here a little bit was, number one, seeing Kouri in regular clothes. Number two, seeing her made up a bit. I thought she'd be in a jail jumpsuit. Let's just start there, and then we can work backwards.
Yeah, it's surprising she's in a jumpsuit or not in a jumpsuit. They must have gotten permission to get her dressed and wear makeup because it's on TV. I don't know why else that she would be. The jury's not there. Normally, you just come in a jumpsuit for preliminary hearings like all the other trials.
Yeah.
So that's a good question. Maybe with somebody on the ground or in Utah can give us that information.
Timbo, you're a little overmodulated. If you can, if there's a dial on your mic and you can just turn it down a notch or 3, that I think that might help. Sorry to.
Does that help?
A little more.
Hold on.
That's getting better. It's
better?
also, yeah, better. Yeah.
Okay.
Thank
All
you.
right.
But by the way, before we go anywhere, I got to say, Tim Jansen, the greatest party man of this century. We were at his daughter's wedding, which was a big honor, and I've never seen a party like that in my life. Tim, have you recovered yet?
Well, we did. Then we did our Christmas Eve party, and then my wife threw a birthday party for me and my neighbor. So we had 3 parties in 16 days.
Yeah.
So I'm partied out.
Here we go. Here's a question that I'm just seeing for the first time. Sorry, I'm new to this case. Just wondering if there's a theory as to why the defendant did what she's alleged to have done, please. She had a boyfriend, a paramour, and apparently wanted to move on. That's what I know. She is accused of killing Eric Richins, who you see there on the right in the white hat, with 5 times the lethal dose of fentanyl. Tim, just explain a little bit about what today is, and today is supposed to lead into tomorrow. For full disclosure, I don't know if I'm going to be able to be here for the entire preliminary hearing today because Reiner went really long, and I'm going to have to prep for the 7 p.m. show, and I've got to get my cardio in today because I committed to the gym, Tim Jansen. But I'm going to be here for as long as I can, and happy to obviously have Tim here. But Tim, just talk to us about this preliminary hearing here and the deal. The judge is excellent, but what she's kind of going step by step here to see, I assume, who can be witnesses at the trial, who isn't, and he's taking proffers, etc.
Yeah, so this is a kind of hearings that should have been done in the Adelson case. a bunch of preliminary motions, right? And so the judge makes a ruling before the trial so the parties know what's coming in. These parties, they did it right. The judge is a brilliant judge. I think he knows the case better than both of the lawyers. He knows the law. He's been more than fair to each side. And this is about whether some experts can come in, whether handwriting expert can come in, whether some doctors can testify as experts. And now they're talking about another expert trying to see if they can keep them in or keep them out. The defense wants to keep them all out. And that's their best goal. And the state's trying to get the judge to say, wait a minute, just let's see what the evidence is, and maybe we'll have relevant. We don't want to disclose our entire case at this point so that the defense knows what's coming, but we think we'll be able to tie it up. And that's what they're not saying, but that's what they're saying to the judge. We think we're going to be able to prove the foundation for these witnesses, but they don't want to tell the defense. And the judge, of course, wants to hear it so he can make a ruling. So you got this push and pull by both sides, and you got a judge in the middle trying to call balls and strikes. So I think the judge do the right thing and tries to be fair, but also he can always change his mind. And the defense is trying to get out all the state's case so they know what's coming. And that's kind of what you're doing in preliminary hearings.
And this is true here from Jamie. There's also a financial arm to this. Prosecutors allege that Kouri Richins fraudulently secured a life insurance policy on her husband's death in January 22. Had financial incentives. She was in the process of flipping a home that I believe was, I don't know if it was in her name or his name. So there are other aspects to this. They met, interestingly enough. He was a pretty successful developer of sorts in Summit County in Utah, and they met. She was actually working at the Home Depot, and that's how they connected. And then things got super messy, where she was having an affair. Other things were going on. She also had previously tried to poison Eric Richins on the Valentine's Day before he died. Kouri here, they're saying, is missing. Sky Lazaro, who's our friend and a best guest. What do you think of this? Her name is Kathy Nestor. She's the lead criminal defense attorney. Is she doing a good job, Tim?
Is that the heavyset woman?
Yes.
She's also doing the other murder trial, right? In Utah.
Yeah, she's doing the Tyler Robinson. Yeah.
Tyler Robinson case.
Yeah.
She didn't do much. The whole hearing was the other defense lawyer. She only got up for like the last 30 minutes. That's all we've seen her do today, was pretty much make oral arguments. The other defense lawyer did some cross-examination and some direct of the experts. I think she knows the law. I'm not sure how her presentation will be. But she clearly, she clearly doesn't want this expert to come in, because she says, well, we got to do this, we got to do that. Well, they should be doing that now. They should have an expert just in case it comes in, and not say, well, judge, if you let this in, she knows better. And she's trying to get the judge to give a ruling she wants.
There's a comment here. Her parents are very rich. I think you might be, if you're talking about Kouri, I think you might be confusing her with Shanna Gardner, who's also from Utah originally, who's involved in a very similar murder for hire plot as the whole Dan Markel case. Kouri Richins' mother actually had a female partner, and she died under mysterious circumstances. So there hasn't been word about whether any kind of investigation has been opened up into that case. And I think her partner died back, I want to say like 2006-ish. It was a while ago. But in light of this death, there was talk about maybe looking into Kouri Richins' own mother's past, again, citing a very similar death. But yeah, this defense attorney, Kathy Nestor, is Tyler Robinson, the man accused of the assassination on Charlie Kirk, same attorney. So she has her hands full. Of course, that happened in the same state, which is why in Utah. But Tim,
she's a little different. She's not the most polished. Mm-hmm. She doesn't give the legal speak. She seems like more like the street fighter type of defense lawyer. I don't see her arguing a bunch of cases. And and she's just that's what I look at her as.
Yeah. Welcome to Dr. Patrice Berry, who's in the chat, and best guest. She's here. Tim, real quick, while we have a few minutes. So again, Alan Jackson announcing that he is withdrawing as Nick Reiner's attorney, and there's some debate. Was it over money or just the fact that maybe Nick Reiner is a really difficult client to handle for obvious reasons? What's your best guess? What do you think?
It could be financial. It could be theory of defense, and maybe he wanted to do one defense and the client didn't want to do that, or the family or whoever was paying the bill didn't want to do it, or they didn't want to pay the fee that he probably charged to go try that case. It could be a combination.
Yeah. Gail here. Gail Sinat. Any relation to Frank? I got to ask. Or Nancy? I got the cases confused. One of them has the company stamping up. That is Shanna Gardner, correct? Out of Jacksonville, Florida. That trial is upcoming as well. When it rains, it pours. Also today was a preliminary hearing that was supposed to happen, I believe, for Ashley Buzzard, who's now accused of murdering her own 9-year-old daughter, Melody. That was continued as well. The other big story, of course, that we always cover, Tim, is Dan Markel. And in this case, Charlie Adelson's appeal, his hearing is coming up, I think on February 3rd. How does that go down? And I think I'm going to have to come up to Tallahassee for that. And I just saw Abby Crossing, who's a friend of mine, friend of ours, friend of the show. She's going to be there.
Yep.
What are we expecting for that?
Well, it's going to be in the first DCA. I've been told that they get 20 minutes each side to argue the merits. It's open to the courthouse. It's a different courthouse. We call it the Taj Mahal. It's a beautiful courtroom.
Tim, if I come up, will you take me there?
Sure. Absolutely.
Love that.
We can go together.
Will you take me in your convertible old school Mercedes?
If we got it out there in the yard, it's not starting. So we did so much construction at the house, I didn't drive it. So now I don't know what happened to fuel injectors or something.
Well, you could always roll me there in neutral. No, we'll figure that out. But 20 minutes, when I read that, 20 minutes aside, that seems like a very short amount of time to argue.
That's actually more than they normally give them. They normally get like 5 minutes. You got to pare down your arguments and you got to answer questions. So 20 minutes each side is it's not bad. It should be pretty good. You're going to hear a lot of stuff that we've talked about over the years.
So, okay. So each side, Charlie's appellate attorney, Michael Offerman, he'll obviously be, I assume, leading the argument.
He'll go first. Yeah.
Yeah. He'll go first. And then the state, I guess, goes after. Okay, so 20 minutes each, and it's before a panel of judges. And then how soon before they make a decision?
It's 3 judges. I think you're going to hear Dan Roshbaum's name a lot, because I bet the best chance of getting a new trial is going to be the conflict, and that he couldn't call his mother as a witness, which would have given him his defense about the conspiracy. And sometimes you can tell by the questions from the judges whether or not they're being persuasive, but then the ruling could come down. It could come down weeks, months later.
Now, a guy like Offerman, who you've said is among the best in the entire state of Florida, when you only have 20 minutes, is he going to be reading something? Because he's got to hit point after point after point, or is he good enough where he's just going to sit there and go from the top of his head?
No, he'll have his main points, his strongest one he's going to hit, and he's going to hit that one, and he'll be ready to go to the other ones, but he knows the judges are going to interrupt him with questions. And sometimes the judges will give you expect more time because they take all your time questioning, but you get peppered with questions. So you may sit there and do your oral argument and time it 20 minutes. You're not getting that 20 minutes because the judges are going to hit you with questions.
Wow. And so how far, I'm just curious, how far is this from the Leon County Courthouse? How far are we talking?
Probably 16 minutes.
So the whole thing will be 40 minutes in an hour probably. Yeah. Wow.
And then you could do a show afterwards. You can, so there's stuff you can do.
Yeah, we're going to, I think I'm going to have to head up there for that. And Steve Cohen, if you do, I don't think I can drive it, Steve, but we'll talk.
I'm curious to see who will be there. I went to one of the, I went to Denise Williams's oral argument for her new trial, and all the lead prosecutors were there, the lead investigators were there. So I'm sure you're going to see a lot of the lead maybe prosecutors there for the oral argument.
And there are no cameras, I assume.
No cameras.
And here's a good question. Is Charlie going to be bussed over from South Dakota for this? He
will not be there. He will not be there.
That's interesting. I wonder what that is like for a defendant to not be there. That's got to be difficult, I would assume. Tim's like, screw that question. Jen and Ken.
No, he's not testifying. There's not going to be any. Charlie's not there to testify. This is just an appeal to what happened in the trial and the issues on Charlie's trial, not about him working a deal down the road.
Yeah, and I'm sure he's going to talk to Charlie right after Ufferman will. But any chance here, anything weird that could happen at this appellate hearing, like implicating his sister, as the question here is asking, or suggesting like some alternate theory or something? Could that come up potentially?
I will tell you, I think if the judges hit on this conflict issue and that there was a clear conflict, and did it prevent him from getting a fair trial, and that he couldn't call his mother because his own lawyer had a conflict, and that there could be a basis for Charlie to get a new trial. I'm curious to see how much the judges weigh in on that issue. That's one of the issues.
Going back to Kouri Richins, it's a lot more fun, by the way, at least for us to be talking about Charlie and Wendy. Awfully quiet on the Wendy front, Tim Jansen. But
I told y'all.
We'll see what happens. But so this Judge Mrazek here, he has to basically decide, is there going to be enough evidence to move forward? There were some issues, Tim, and I know you're kind of picking up this case midstream, and to be perfectly transparent, I haven't really dived back into it in a while, but I was pretty mired in it at one point. But I know at the beginning, there were issues related to search warrants, what could come in, what couldn't come in. There's also this so-called walk the dog letter, which is not unlike the Donna Adelson letter. It was almost like a script for her brother to follow. I assume that some of these more damning pieces of evidence are going to ultimately be admitted in. I mean, I feel like we always hear this, like, the judge is going to review the evidence, but ultimately the bigger pieces and the meatier pieces of evidence generally tend to find their way in. Is that true?
Well, listen, there's a thing called Brady, and Brady means that the prosecution has to turn over any exculpatory evidence towards the defendant or impeachment for witnesses. In this case, there was. I did some research, and there was completely the person that says they sold the drugs to Kouri later changed her testimony and said she didn't sell fentanyl, but she's another drug. And they did that interview and never turned that over to the defense for a long time. And then they found out, they said, we don't need to turn it. And that would be impeachment of that witness. It is exculpatory towards the defendant. And the state says, well, that person really doesn't know what's in the drug when they buy it, and it could have had fentanyl. That may be true, but that's still Brady material that should have been turned over. And the remedy is either the judge keeps the evidence out, or now that they have it, he's going to basically say, you should have turned it over. And they should. And it gives you a little glimpse of what the prosecution thinks about Brady. They don't take it serious. This is a murder case. That should have been turned over. When the key witness who said she sold drugs that the wife used to kill the husband, he died, and that witness later says to two investigators, I didn't sell fentanyl, that has to be turned over. The serious problems in my mind.
Yeah. Tim, this is putting the cart ahead of the horse, but let's just say she's found guilty here, right?
Yeah.
One of the interesting things, she tried to allegedly poison her husband on the Valentine's Day before, and it failed. And then
Right.
she succeeds. She did this with 5 times the lethal dose of fentanyl while her own children, you're looking at them there, while they're at the house. Is that something that a judge takes into account at sentencing if it gets to that point, Tim?
Listen, if she gets convicted, she's getting life in prison.
Mm.
And no ifs, ands, or buts, you know. Just like when Donna got convicted, the judge was giving her life, required life.
The issue before the
forever.
court
Here's
is
Judge,
the defendant's
Richard
motion to
Mrazek.
exclude Dr.
Guy's
Sherry
great.
Venino, who is an expert noticed by the state or disclosed by the state to give testimony about domestic violence relationships, to include characteristics, dynamics, patterns, and victim trauma. Dr. Venino is disclosed as a blind expert who is being offered to testify regarding a set of principles regarding domestic violence relationships without having either viewed or opining on any case-specific evidence. The state asserts that characteristics of domestic violence victims are relevant because when applied to the facts of this case, they will help a jury understand, for example, why Eric Richins continued to live with the defendant after she allegedly administered fentanyl to him on February 14, 2022. Currently, the court has not seen in the record a non-speculative basis for the jury to draw an inference that Eric Richins had any subjective knowledge of Ms. Richins' alleged attempt to poison him on February 14, 2022. And in the absence of a non-speculative basis for the jury to draw that inference, that is, that Eric knew that his wife had attempted to hurt him, there's no relevance to Dr. Venino's testimony regarding the dynamics of domestic violence relationships because there would be no foundation for the jury to conclude that the relationship between Kouri Richins and Eric Richins qualifies as a domestic violence relationship. In the absence of that foundation, Dr. Venino's testimony would not be helpful to the trier of fact under Rule 702A, and given its lack of probative value, it would be inadmissible under Rule 403, not only as not being relevant under 401 and 402, but also under Rule 403 as inviting the jury to speculate about whether there was some other evidence of a domestic violence relationship between these two that wasn't in evidence in the court. It might confuse the jury regarding the testimony that is admissible. It might mislead them regarding the reasonable inferences to be drawn from it. So sitting here today, there isn't a basis to allow Dr. Venino to testify. However, the state makes a reasonable point that the court hasn't seen all the evidence, isn't aware of all the evidence, hasn't seen how it would come in, and the state may yet be able to lay the missing foundation during its case in chief. And so while the court determines that sitting here today, there is not a basis to allow Dr. Venino to testify, the court acknowledges that that basis may arise through the state's case in chief if the state in its case in chief lays a sufficient foundation for the jury to draw a non-speculative inference that Eric Richins was aware that defendant tried to hurt him on February 14, 2022, the court will revisit defendant's argument that Dr. Venino's testimony should nonetheless be excluded under Rule 403, given the entire context of the evidentiary record at that point. In so ruling, the court also rules that Dr. Venino is qualified to offer this type of testimony under Rule 702A and that her testimony, if it becomes helpful to the trier of fact, and if it survives a 403 balancing test, satisfies the minimum threshold for reliability under Rule 702B. Ms. Shervanek, Mr. Bloodworth, do you need any clarification of the court's ruling?
No, Your Honor, that's sufficient. Thank you.
Ms. Nestor?
No, Your Honor.
Okay. All right. Any other expert witness issues we need to handle today? Ms. Lewis?
Not today, Your Honor, no.
Okay. Mr. Burmester?
No, nothing.
Ms. Shervanek?
No, Your Honor.
All right.
No, Your Honor.
Okay. Sitting here at this moment, I'm not prepared to get too deep into the other motions in limine. May we take those up tomorrow? Any practical considerations that we need to think about, or are we just going to handle those one at a time tomorrow based on the papers?
Those are mostly going to be mine, Your Honor. Some of them are Ms. Lewis's.
Yeah.
Alex has, I think, one or two. Mr. Ramos, sorry. The only question we had, and I'm just not sure. So these motions were filed privately because they deal with evidence that we're asking not be admissible at trial. I didn't know if the court intended to have the hearing public or not public, because once it's aired, it defeats the purpose of why it was all filed privately.
I mean, there is some space between the way we talk about stuff and the documents. For example, there are certain documents or transcripts in which the state is seeking to admit a portion, but not the whole thing. And it's sometimes because the part they're not seeking to admit would be unfairly prejudicial, not relevant, inflammatory.
Right.
Nonetheless, your point is well taken. Do you have a request?
Obviously it would be our preference that it all be private, and then maybe your ruling could be public.
Sure.
Because your ruling can craft it in such a way that you don't reveal inadmissible evidence. But it seems to me that the danger that a bunch of inadmissible evidence is going to be broadcast to all of our jury who now have received jury questionnaires and know they're on deck,
right,
could be problematic. So we would ask that the hearing be sealed and then maybe just the ruling be made public.
Okay. What's the state's position?
No objection to that, Your Honor.
All right. Tomorrow, January 8th, the court has set a hearing to hear oral argument on numerous motions in limine filed by the state and by defendant related to a number of pieces of testimony, documents, audio recordings, video recordings, other pieces of evidence. The admissibility of those things is as yet undetermined. And the court is persuaded by counsel's stipulation that to ensure the integrity of voir dire and the jury pool, and in recognition of the fact that potential jurors have already filled out their questionnaires, and so there would be a reduced ability tomorrow, the day after, to investigate whether they're exposed to information regarding inadmissible evidence. The court finds that it is necessary to close tomorrow's hearing to the public and to seal the audio recording of it so that it is available only to counsel, but not to the public at large. The court's ruling regarding what is admissible and what is not will be part of the public record. Any clarification on that, Ms. Nestor?
No, Your Honor.
Mr. Bloodworth?
No, Your Honor.
All right. Folks, we're likely to get some weather tonight, tomorrow morning. Is 9:30 an appropriate time? Do you need a little more travel time?
10.
That's fine. 10 a.m., Mr. Bloodworth?
Yes, Your Honor, that works. I have one other
Please.
issue.
Too, but go ahead. Oh, I just had a question. I don't know if you're prepared to answer this, but we do have a number of motions tomorrow. And in terms of expediency, it would be helpful if you have specific things you'd like us to be prepared to address. Maybe if we knew some of that in advance, if there was particular case law you want to discuss,
No, I'm going to be going off. I mean, I do have lots of practical questions about, all right, who's offering this? How's it coming in? Right? Is this case in chief? Is this impeachment? I need to understand the order of events. But I will go off the papers. And I'm happy to follow your lead in terms of the order in which you want to do things. So talk to each other. If you want to do Mr. Ramos's first so he can go do something, that's fine. Will you just tell me how you want to?
He doesn't get to leave.
Okay. Anything else, Ms. Lewis?
No, Your Honor.
Mr. Bloodworth?
Your Honor, clarification on the sealing.
Yeah.
The victim and defendant's family are permitted in the courtroom.
Certainly victim representative.
Just one.
Just one.
Okay.
Yeah. Would be similar to what we would do for jury selection, for example. So during individual voir dire, victim representative is allowed to be present. I don't even know if Ms. Richins wants a family member present.
I'm sure. No, out of abundance of caution, because they've received subpoenas, it's
Right.
probably better they not.
Okay. So if you would pick a representative for the Richins family,
I think there's two that are designated.
that's fine. I understand. Yeah.
Your Honor, one more thing. The state in some of its motions have styled them as motion to pre-admit.
Right.
The defense in some objections had said the state lacks, or the court lacks authority to pre-admit. I don't fully know what the answer is, but
Well, no, I certainly have the authority to say that, for example, defendant has admitted that she wrote a certain letter, so 901 is satisfied.
sure that. But as far as the relief the state is requesting, if the state has styled it as a motion to pre-admit, the state would like to amend any of those stylings to a motion to determine admissibility.
Understood.
Thank you.
Okay. Some of my questions will be, is there a genuine issue regarding the the authenticity
Sure.
of this document? Who's your witness that's going to bring it in? Something like that.
Yes.
Okay.
No, we're nothing further.
Okay. Ms. Nestor, Ms. Lewis, Mr. Ramos, I'm not suggesting that the defendant should do anything other than put the state to its burden of proof and require them to lay a foundation for stuff they want to admit. However, I do want you to be at least a little bit thoughtful on both sides of the V here about the juror's time and the court's time. And so if there are indisputably authentic documents that you can stipulate regarding authenticity and foundation, but you want to reserve and then discuss your arguments regarding admissibility,
Right.
let me know which one those
Your
are.
Honor, I actually have been spending a great deal of time on that. I've come up with lots and lots that we're willing to stipulate to authenticity. I told the prosecution I would get that to them, I think Monday, but something came up in my family and I wasn't able to do that, but I will try to get that to them by Friday.
Okay.
But there's quite a few documents that we're not going to have a problem with authenticity, and we're not going to ask them to bring in sponsoring witnesses or
Perfect.
like jail calls and
Yeah.
bank records and pictures and all that kind of stuff. And I'm doing it one by one by one, and we'll have a comprehensive list by Friday, hopefully.
Thank you.
Thank you.
Okay. Mr. Bloodworth, anything else today?
No, Your Honor.
Okay. Ms. Lewis?
No, Your Honor.
All right. We'll reconvene 10 a.m. tomorrow morning. 2 victim representatives are welcome to attend. The rest of the public will be excluded tomorrow. Please travel safely. Nice to see all of you. Please take care. Court's in recess.
And with that, that is all you're going to see of the Kouri Richins 2-day preliminary hearing. It is now 1 day, and you just saw the only day. Judge Richard Mrazek, who again is excellent and has that mellifluous voice, he just heard an argument from Kathy Nestor, who's the criminal defense attorney representing Kouri Richins, and she said essentially, we are worried about tomorrow, and it's because there's going to be discussion of possibly admissible evidence, and the jury summons have already gone out for this trial because it's going to be held in February. And now you're going to televise this potential admissible evidence. And she made the argument to the judge that it needs to be sealed. and the judge asked the prosecution if they had any objections or any argument to make, and they said no, that they were fine with that. And with that, the judge said, you know what? It's a good idea. I am going to cut the cord tomorrow and will not stream this live. So we go from a live 2-day Kouri Richins preliminary hearing to what you just saw today. In terms of tomorrow, they said that there are going to be oral arguments on motions that are in limine, motions to suppress evidence is what that means in English. And it regards testimony from witnesses, audio that could come in, other sorts of documentation. These were the examples that the judge gave. And now, because these jury summons already went out in Summit County, Utah, we, the public, will get screwed. We will not be able to watch this. So it's kind of a bummer because we were looking forward to bringing it to you. But don't worry. When one preliminary hearing goes, there's always another, and it's heating up right now. Looking ahead, just so you all know, tonight look at this, Betty. It could be my voice, but I think she's talking about the judge. Really, you don't like his voice. Betty, I'm curious why. He seems to have an amazing voice by all accounts. However, and I reached out to Black Widow. I know I like to digress, but I got hooked on a show it's on Amazon, but it's from the BBC. It's called Blue Lights. It takes place in Belfast, Northern Ireland, and it follows a police precinct, a police department up there. They go out on calls, and guess what? Black Widow had never heard of it. I'm curious if any of you have heard of a show called Blue Lights. It won the BAFTA Awards, which is a big deal in Europe, but that's neither here nor there. Back to Kouri Richins. So the preliminary hearing, day 2, is not going to happen. As far as today, we already, the big headline is that Alan Jackson has dropped out as an attorney for Nick Reiner. His arraignment has been continued to February 23rd. On February 3rd will be Charlie Adelson's appellate arguments, and I think I'm going to head up there, and maybe Steve Cohen will join me for that in Tallahassee on February 3rd. Tonight at 7 o'clock Eastern time, Phil and Scott are back, and we are diving back into the Tepe murders. That is the 37-year-old dentist in Columbus, Ohio, essentially executed an assassination-style execution in his home of both he and his 39-year-old wife, Monique. We had a family member on yesterday, the brother-in-law, who came on to tell us what a domestic call was from their house was all about back on April 15th, and it was not Monique Tepe. That's what he told us on our show last night. So we've been all over that story, and we're going to continue to cover it with Phil and Scott tonight. And then I would say normally the plan was to be back for the preliminary hearing tomorrow, but that's not happening. However, beginning next week, the so-called au pair trial is kicking off in Virginia. That is an au pair who started having an affair with the husband who had hired her. They lure the wife, who was home actually, but lure another gentleman in under some weird fetish site into the home, and they murder the unsuspecting person and the wife. And now the husband is set to stand trial, and the au pair, I believe, is going to be, correct me if I'm wrong here, I have to double check this, might be the state's witness in this case, star witness, but I have to double check that. It's been a minute since I have looked at the case, but we are going to bring you that trial live next week. But in the immediate future, tonight, 7 p.m. Eastern time, we'll be back on the Tepe murders. We'll be doing that tomorrow, and then Karm and I will likely preview the au pair trial and get Karm's take on this on Friday. Appreciate you all being here. Things are starting to get busy and heating up, and you were just watching the preliminary hearing here for Kouri Richins. Her trial is set to kick off toward the end of February. With all that said, want to say, love you, America. Justice for Eric Richins here. This was once a happy family. Just takes one crazy accused killer here in Kouri Richins to upend an entire family. We just saw that with the dentist, the Teppies, and we just saw that with Nick Reiner. So there's always a ripple effect with the victims here, and it stays with these families long past our coverage of any of these cases. So remember the true in true crime. Love you all. See you at 7 p.m. Eastern Time.